let's first go, welcome. All right, so joining us now, another board member, Jared. Ugly Drive? Yeah. All right, so let me go back to cases. Case Van Stein made a motion to nominate Fred Dalma as chair. Is a second to that motion? Second. Any other nominations? Any seconds to Craig's motion? Second. Okay, so we will do a voice call and select between those two. Is there any other nominations? No. So we'll be choosing between Fred and Ari. So I'll do a voice call, and if you could indicate your vote, and we will tally that. Thank you. A good point. We will be recording this meeting to help in the preparation of the minutes. So there is voice recording. I don't think we're doing video recording, but we will be doing voice recording for the board members. If you want to speak, please use the microphones. And if you'll notice in the middle of the microphone, there's a spot that says push. Make sure the green light is on your microphone. You might want to make sure that's off when you're not intending to speak to the audience, because you never know.
No video though, huh? Shoot, I wore the wrong hat.
All right, so what I'll do first is ask for those that are voting in favor of Fred, and then I'll go back and ask for those that are favoring Ari, and then we will tabulate those when we're done. Jared Bordes, Fred?
No.
Ari for Fred?
No.
Fred for Fred? William Dyke for Fred?
Yes.
Mike Gallo for Fred?
Yes.
Craig Gordon for Fred?
No.
John Moons for Fred?
Yes.
Tony Noons for Fred?
Yes.
And Art's not here yet. Case Van Stein for Fred?
Yes.
Okay, and so we'll go, it sounds a little repetitive, but we're going to go down and ask the same question. The same folks, just whether or not you favor Ari.
Can we vote yes both times?
I hope not. I suppose you could. Jared Bordessa for Ari.
Yes.
Ari DeYoung for Ari.
Yes.
Fred Dalma for Ari.
No.
William Dyke for Ari.
No.
Joey Fernandez not here. Mike Gallo for Ari.
No.
Craig Gordon for Ari.
Yes.
John Moons for Ari.
No.
Tony Noons for Ari.
No.
And Case Van Stein for Ari.
No.
Okay. So I have 6 for Fred and 2 for Ari. So we now have Fred Dalma as our new chair. Let's go ahead and take care of the vice chair and get that out of the way, and then we'll, again, break for 5 minutes.
I'd like to nominate Ari.
Second.
So Case has nominated Ari as a vice chair. Craig has seconded that. Are there any other nominations? Given that there are not any other nominations, we'll just take a voice vote. All those in favor of RA for the vice chair signify by saying aye.
Aye.
Any opposed? Okay, so we have a chairman, Fred Dalma, and vice chair of RA. So we'll be breaking for a few minutes, and if you gentlemen could, I guess, just meet right up here in the front, and staff would like to just have a brief discussion with you.
You're gonna read the rules.
Man, I'm not much for rules. It's not gonna go well.
You got Bobby's Rules of Order.
They're bringing in. Are they gonna move here in the front?
Do us good, Ari, do us good. You know where it's at? No. When you go out the door, make a first left, you go into the doors, make a quick right, it's right there, left and then right.
It's further down for this. And so as long as there's very clearly, common rules heard so far on the agenda item, agenda item later. But other than that.
Do you have Fred Dalma's telephone number? Do you have Fred Dalma's telephone number? And I'm gonna wanna have that in case I can't can't show up, or he can't show up, I wanna make sure we coordinate.
Yeah, we can get that for you. I don't think.
Okay, I'll ask him to.
Okay, good.
I'll ask him.
Getting back to order on the meeting, next item for business is the QIP update.
Thank you. So I just wanted to give an update to the board on where we're at with the quota implementation plan, how things have been running up to this point, and just, like I say, bring you up to date on where we're at. So we started running the quota implementation plan with November milk. So we have a couple of months under our belt, which we've been going through the process. It's been a bit of a learning curve for us as we receive information from the handlers. We're using the same reporting forms that are used by the Federal Milk Market Administrator's Office. We're doing that so that handlers don't have to learn two different reporting forms. They can just fill out one form and send it to both the federal folks and us at the same time, making it more efficient for them. So a bit of a learning curve there. It's been interesting seeing just some small nuances between the federal program and our program and how and what they report. We have heard from a number of entities who obviously don't, I shouldn't say appreciate, but prefer not to be paying the quota premium. Obviously, industry's heard a lot of discussion, and partly witnessed by the number of folks in the audience today. This definitely is a hot topic, and so again, we've heard from a couple entities that don't want to pay, and we're hearing rumors of some folks that are misreporting or perhaps changing how they are moving milk around to avoid paying the 38-cent premium. But each month as we've gone through the process, we're learning a little bit more and getting the process turned around quicker, and we're pretty comfortable on where we're at today. Any questions from the board?
Don, I've got one. I don't know, how do you guys know who you're assessing if we can't get a list of who we are assessing?
So we're getting a list from handlers as to how much milk is being produced at each farm. And that's a farm by farm. And what you have asked for is a list of producers. And to compile that list of producers is a little more cumbersome because there are some farms that are, or some producers that own multiple farms. And so that's a manual task to go through and compile that list. And so it's not something that we do each and every month. It would be a task that we would do when we're required to in order to tabulate a referendum or decide if we've met that threshold of the 25%. So again, it's just a matter of having the staff time to do that. We're down to 5 staff instead of the 50 that we had in the department at one point. And so just getting through the monthly process of running the pool as we go through this learning curve, it's we don't have the 2 days a month that it would take to develop that.
Okay, I understand. We've talked about this many times. What I'm looking for is just not to segregate the multiples out, but just the listed. Who are the 1,000 or 1,253 dairymen that are assessed at 38 cents? That's got to be a simple push a button. Who you're sending out the bills to, and who's receiving that $13 million should be another button. I would think take 2 seconds to run those lists because you're currently, I hope, at the end of each month you're billing the right guys. The list that I received from the state, I paid $50 for, has dead people on it. It has people who've been out of business for 2-3 months, and from one guy 6 months. So it leads me to believe, they say, well, who are we assessing and who's paying? And I would think that list would be a simple list to, not asking for the official list for if we went to a petition, but just who are the people that are being assessed? For us to give the information here, and who are the quota holders and how much, how can we give good advice to the Secretary Ross if we don't have the key information of who's all involved in this program, who's paying and who's receiving? I think that's, I think it should be mandatory that we get that type of information.
So we Go ahead, Fred. We do have a list of who we are collecting from and who we would be paying out to. But providing that information the way you just asked for it would be giving out some proprietary information, and we can't do that.
And what's proprietary? What are you saying there?
So if we were to give you a listing of who received credit for quota and how much of a credit they received, you would be able to determine how much quota they own. And the department has historically determined or decided that the quota ownership on a producer-by-producer or farm-by-farm basis is proprietary information.
Case.
I don't have any problem with the totals and numbers of how many are participating in all those divides, but the particular information with names and addresses, I would agree with Don that should stay within the state and should not be public because it could be misused, and I wouldn't want to see that happen.
How it could be misused, and I think it'd be important because if we have a guy that's got 300 cows and he's got quota for 2,000 cows, that would be a question mark. How do we audit that, or we look out for our interest of who's getting paid and how much? I mean, that's what this whole QIP is about, isn't it? Is assessing and paying.
So the issue that you just bring up, that would be an issue that our auditors would look at when they go out to audit a plant. They would look at each dairy farm, how much milk is coming from that farm, how much quota they own, or how much quota is assigned to that. And so we would be looking for that.
So my question is then, we've got, I know, well, Wilbur Hettinger, most of you guys knew who Wilbur Hettinger was. He died 8 years ago, and he's on the list. So the auditors obviously aren't doing a good job.
So as you and I discussed last week, that mailing list that you received does not come out of our accounting system. That's a separate database. Okay. And there may be instances where we have missed removing somebody from that mailing list or adding them on. It's a separate system or listing than what we have for the official accounting.
How do I get the other list then?
I can provide you a list of all the names that are on that. And anybody that has milk production for a given month, I can give you that list. I can't give you their volume, or I can't tell you whether or not they own quota, but I can give you a list of the names.
That'd be good. I'd request that then. Thank you.
And Fred, just for the record, just make a point that Mr. Van Beek has joined us. Oh. So you were on the 99 parking lot this morning? Yeah. Thank you. Any other questions on QUIP update?
Was that a hand, Ari? I didn't see. Oh. Moving on then to the draft.
I kind of do have a question. You were going to start with, with taking money in and then distributing the money out. And in the beginning, it was going to be a bit ambiguous as to, how much money it was going to take to run it. And is that coming in as expected, and are you kind of on schedule with that? And
It is coming in as expected. We were going to revisit that after a number of months to determine whether or not we needed to change the withholding rate. It's about 38 cents a hundredweight right now. But based on what I have seen for the first 2 months, that is more than enough monies to pay out. So we may be actually lowering that rate.
that's what I was curious about. Thank you.
Don, I got one more question, Fred, if I can ask this question. I know that we can only discuss what's on the agenda, but I'd like to get on the next agenda if we can about discussing hardship cases of those guys who want to sell their quota, who purchased it in the last year, so there's a 2-year restriction. And how do we go about trying to lift that restriction, and or if not, how do we apply to do a hardship case? They got to call the department, or how do they do that?
So the hardship provisions are written into the QUIP, and if an individual producer wants to petition the board and ask for a hearing before the board to present a hardship issue, they certainly can do that. They just need to send something into the department indicating they want to get before the board or have a hearing before the board.
But to make a policy change of changing that 2-year rule, how do we do that? I just got to get a discussion, be on the agenda for the next meeting?
Yes, and you would have to amend the quota implementation plan.
Okay, thank you.
Moving on then, draft petition procedures.
Okay, so if you look up on the screen, we have the, if you recall, December 19th meeting, we went through and developed some draft language on the procedures the department would follow in the event that we received a petition. So at that time, we were operating without input from council. And subsequent to that meeting, we have received input from departmental counsel, and we have issued sent out a revised version of that document. And so if you look up on the board right now, Candace, this is which version?
This is the version that has edits from council.
Okay, thank you. So the version up here has the edits from council, and as Candace points out, that is also in front of each of us here. And so, based on department council input, we have this amended version. Michelle, would you like to provide any input, or do you want us to just work through here?
Are you going to go straight to that section, or are you going to go through the whole document, or where?
Let's go straight to the section where we have the revised draft as a result of the working draft. And so that, again, is what's up on the board now. And as we go through this document, board provide input, suggestions. Again, this is a draft document, so we will be amending it on the fly. Candace will be making edits to the document on the screen as we go through. And then when we're done working through this, the board can take whatever action they deem necessary or appropriate. So Michelle, if you maybe could make some general comments on your input.
Well, can you hear me? Oh, there you go. Thank you very much. Good morning, gentlemen. The section that I was most concerned about when I saw the draft was the verification section, so that if you received a petition, the draft language I received from the program was the third bullet on the document that talked about sending out a letter requesting a producer to sign it and basically attest to the fact that they had signed the petition. So my concern was that we have no legal authority to require them to do that. That when we receive the petition, there's a process by which the program would verify those names on the petition when it was originally received to show that it was a producer, to match it up, to make sure that there was a producer. There's so many process issues that could arise by sending out a letter and then expecting somebody to send it back to you. And if you don't receive it, if we didn't receive it in the time allocated, to basically disregard that signature and invalidate that person's signature on the petition, that raises all kinds of legal issues. So I came up with the language in the first two bullets. Obviously, if you receive a petition and the signatures have been notarized, that should give everybody confidence that the person that signed it is the person. And then the second would be that you place the burden on anyone who believes there has been a fraud perpetrated. So if somebody believes that somebody has forged signatures on a petition, that person should bring forth the evidence that they have, and then the department could conduct an investigation into that after it had gone through its regular routine of checking the signatures against their list. and then we could initiate an investigation. That reduces the legal risks significantly.
Any questions from the board, comments from the board?
Might as well trying to remember what the thought process was, but the thought process was not, I don't think the thought process was forgery. The thought process is that we're trying to establish that, that each individual that signs it wasn't on the fence and got his arm twisted or had somebody standing in front of him with a clipboard asking him to sign it. And we all know in that kind of a situation, it's difficult to say no. So there are people that could sign it under some
Duress?
some thought, like, yeah, whatever the word is, and that's the thought process. I don't think that forgeries was the issue, and having a notary verify it, I don't know what exactly that accomplishes, because, but that was the thought, that to make sure that anybody that signed it, if you get it by mail, it's easy. You get it by mail and you sign it, or don't sign it. But if somebody's standing in front of you, we all know that it's more difficult to say no. So that was the thought process.
Isn't it under the regs that you can withdraw your signature of the petition at any time, up to the time it's submitted, right? If you were coerced into it, you can withdraw your signature at any time. That's in the regs here. Is that, am I correct?
Is that
here?
in the, I don't remember that being, is that part of the, I don't remember reading that in part of the procedures.
It says
Is
the petition, if the petitioner withdraws the petition, they may resubmit a new petition, but it didn't go into individual.
Yeah, it's not individual
signatories.
signatures. Would be the entire petition.
Question, was there a time limit on how much time a guy could be busy collecting signatures, or I don't remember that? Shouldn't there be?
No,
Why?
there's no,
Yeah, why would you need a time frame? I don't,
Stuff happens.
well, we would have no way of knowing when he started collecting, he or she, and when they stopped. There, we can receive, or we receive petitions all the time, and there's no time restraints or nothing in our rules beforehand that say it has to be received by or on such and such a date.
So if some of these signatures are 4 or 5 years old, wouldn't that, mean anything?
If they were valid signatures, we wouldn't have any way of, or reason to say that doesn't apply.
I have one question. The signature on that petition, each petition has a signature. So that is what has to be sent in, right? Or is it a whole one petition with 100 signatures?
It would be one petition. We're looking at receiving one petition and then signed by multiple individuals.
But each signature would have to be, under the suggestion, notarized.
no, well, I'm not suggesting that it be notarized, but I'm suggesting that if somebody submitted them that way, then I think, everybody, any concerns that they were forged would be removed. Duress, I didn't address duress, but I'm not suggesting that be a requirement at all. Because I think we have a process internally that can verify if there is a producer under the name Jane Doe or John Doe.
How would the state authenticate that the person signing has the authority to sign for the dairy? Like in the event of a partnership, who has to sign? Do all partners have to sign? Or if it's, not just a sole proprietorship, who has the authority to sign the petition?
If we received a signature from a member of a partnership, and particularly if they have quota, we have those signatures on file. And so we can verify, looking at signatures, that that person is a member of that partnership. We wouldn't have any way with the information we have on hand to say, no, you're, under your partnership agreement, you can't sign this. It has to be all 4 or 5 of you. That would be something internal. What we would do is, anytime we receive a petition, we post a petition along with the signatures. And so if somebody thought that, or somebody signed as a partner saying, hey, I'm representing this partnership, and their other partners saw that, they could bring that to our attention and say, Madam Secretary, this individual had no authority to sign on behalf of our partnership.
Yeah, you have to keep in mind that partnerships could be not equal partnerships. There could be, so that might have a bearing, but you kind of covered it because you said the other partners that once you make it public who signed it, I suppose they could act upon that.
No, I don't think you can really get into equal partnerships and non-equal partnerships, can you? Because then that's kind of like saying big dairymen against small dairymen. I mean, that shouldn't mean anything in there.
And again, if we had a signature and we were comfortable that was from somebody that was a member of that partnership, we would post it out there, and if there are other members of that partnership had issue with the authority of that individual, then they could bring it up to us. And that wouldn't have anything to do with herd size or anything of that sort. Just that would be an internal issue within the partnership that we would have to look at.
So if a person had 10% ownership in a dairy and he voted with, or voted a certain way, that 10% would vote for the whole dairy? Does that make sense?
So at this point, we aren't addressing votes per se. We're talking about petitioning, asking for a vote. And so up front, we would have the petition come in with all of the votes, or I'm sorry, not votes, all of the signatures asking for or supporting this petition. If we get that a threshold of 25% of the producers, then it has to go to referendum. So this would be before the voting procedures are in place. And so once we go to a referendum, the way we conduct referendums is that we, the department, instead of receiving something from industry, we, the department, prepare a ballot. We have information on that ballot that is unique to that business entity. We mail it out to that business entity, and then it's up to that business entity to fill that out and send it back.
Excuse me, Don.
Yes.
My understanding and memory is the petition comes and we get 25%, it goes to a hearing in front of this producer review board.
There is a provision for that to be reviewed and for the board to make a recommendation. That's correct.
There's also provision we can skip the hearing also. The 25%.
Okay, Candace, do you have the quip language up there? Yeah. Okay, so section 1103, upon receipt of a petition signed by at least 25% of market milk producers regarding the amendment or termination of this plan, the secretary shall convene the producer review board to review the merits of the petition and make a recommendation to the secretary. If the secretary finds that the plan no longer tends to effectuate the purpose intended, termination shall be submitted for referendum in the same manner as provided for its initial approval. So yes, if we get the 25%, we would have a meeting of this board.
So are we throwing out the section 62717? We're not operating under that. Isn't that where all that stuff come from, is from 62717? Because here it says, shall submit a plan for termination upon a receipt of the petition requesting termination signed by the producers. It says you can producers can bypass the hearing process and force a termination referendum if they have 25% of all producers.
Hang on a second, let me grab my coat.
Thanks.
I didn't think we were operating under that plan anymore.
We're not. We're operating under the QUIP plan, which
Yeah.
we adopted, which was approved by 90% of the producers. That's what, and that
Approved by
procedure.
87 producers who voted, not 90% of all producers, just who voted.
Anyway, that's the approved plan that we're operating under, not the old language.
So, all right, where you're looking at 62717, that is under Chapter 3, which is the Gonzales Milk Pooling Act. The QUIP was authorized in Chapter 3.5,
That's correct?
and so we're under that Chapter 3.5. It authorizes the department to have a standalone quota program, and this language that we're reading is out of that standalone quota program.
So are we operating under that also?
So that 6.2, there are provisions in Chapter 3.5 that talk about referendum process. And let's see. Beginning with 62751 through 62754, which you gentlemen won't have in front of you, but those are the provisions in Chapter 3.5 that refer to the referendum process.
62755 you're kicking out?
We're not,
I have this one already.
so when we conduct the referendum, we would conduct it in the same manner that we used when we implemented it. And we refer back to that section when we're talking about the number of votes needed, meeting that threshold to 50% and 65% for volume, et cetera. So it gets a little cumbersome because there are provisions in different sections, or I'm sorry, different chapters of the code.
Okay, well, I would challenge that the 3.5 includes the 62755, which says we can bypass. So we can discuss that another time.
Yeah. So for today's meeting and the purpose for today, we're going to focus on the QUIP process.
Okay, proceed.
Okay, so we had council input. Any thoughts on council input? We have the draft document that was sent out, was referred to, or it's titled revised draft. And Candace, if you could bring that one back up. And if you look up on the screen, Candace has highlighted verification options to be presented at the March 6th PRB meeting. So at this point, I think it would be appropriate to get the board's input on the options that were presented by council and your thoughts on including those in the document, the procedures document.
Just
Yes.
for clarification, the third bullet is the one that was presented at the December meeting with a few modifications. The one that the council has offered as options are the first and the second as well. So the third one is sort of what was put together in December. The first and the second are the new options or possible options.
Does everybody follow? So If you look at the document in front of you, that's got 3 bullet points. That's the one Jeff was just referencing. The first 2 bullet points are the suggestions of council, and the last one is language that we developed on December 19th.
It would be helpful if we could just identify what's coming out of the codes and what is the additional ones that we're trying to add on to here. This would be nice to know.
Okay. So we're asking for input on, if you look at the screen bullets, points 1 and 2, which again, they're on this document in front of you that's verification options for the board to consider. So we were asking you to consider including bullets 1 and 2 in the document that we worked on in December.
Well, I would vote that we would, but
Okay.
I don't know if we're ready for that yet.
Well, I'd like to ask legal, can we do that?
I'm sorry,
I wanted to ask legal, can we take outside stuff and suggestions and change?
Well, this
put
is
in
your-
codes?
this is what the review board was brought together for, was to bring together guidelines and procedures for the QUIP. And so this is just adding into a document that you guys prepared, I think, or voted on in December.
And we can do that legally.
Well, these aren't regs. I think that there are weaknesses here, and that the whole QUIP program was adopted without going through the regulatory process. So, I mean, there are, for a lawyer, that's a concern, but that's how the QUIP is operating now. So this is an extension of that. You're saying if we get a petition, how are we gonna review that petition, and what's the process gonna be, right? So this is what direction that you're giving to the program.
But isn't that process established in where we just talked about the 62717 of those?
Craig, can I respond to that?
Sure.
That decision and the QUIP was established over the 2 years or whatever we met.
Right.
And the sections which stayed on is included in the QUIP, and the sections that were left behind, according to our ability with the legislation passed, that's done. That's over with. We're not discussing that in this thing. What we're discussing is what we worked on last December, and we're modifying that according to some suggestions. Had nothing to do with sections you're talking about. They're moot. They don't mean anything anymore to the standalone quota program.
Right.
That's the way I see it.
Does council agree with that?
Yeah, this is a whole new process. I mean, we're following, obviously, some things that we did similar to other petitions and referendums, right? But this is direction to your program staff that have to run this program. This is direction to them that if you receive a petition, what's going to happen? You know, and it explains everything, that you will be noticed, it'll be public, they'll count them, you know, this is basically guidelines to give you assurances as to what will happen when a petition comes in. What's Dawn and the team going to do when they receive that petition? This lays it out for you and for the public and all the producers to understand this is what happens.
So what does council have trepidation about as far as the regulatory aspect?
Well,
of this?
it's not adopted pursuant to the APA, right? So, but the fact is that when we started organizing these meetings of the review board, we're following the same requirements of the APA. It's a public meeting, things are posted, things are noticed for 10 days, there's public comment, we consider. So we're doing everything, but we're not sending it to the Office of Administrative Law to approve it and post it as a regulation. But everything is similar. But anytime you do that, there's a weakness that if somebody wanted to challenge it, they would challenge it and say, well, you didn't adopt it pursuant to the APA. But we did. We haven't sent it to the Office of Administrative Law.
Okay, thank you.
So we can just, any part of the process we can change? I mean, I could say let's talk about not even 10%, not 25%. I can say that, 10%, we just talk about that?
You can make that recommendation and see how your fellow board members respond. I don't know if, I mean, Sure, make the recommendation.
It seemed like there was a goal of trying to get some verification of the signatures. Is there any other way you see possible to verify the signatures that you feel comfortable with? Or is it just, we have to say, hey, we don't trust this signature, therefore we'll challenge it? Is there any form of verification that you seem possible?
Yeah, I don't think, I mean, I was surprised when I saw this. I wasn't at the December meeting, and so I was surprised to see this because we have a process in place that we have used, that the program's used with other petitions and referendums that's worked. We've never had any issues with it. And that was when they come in, they verify those signatures to make sure it hits the 25% mark. We've never had any issues with it. So I thought that that process worked fine. My recommendation here is only in response to the language that I saw, because I was told there was some concern and they wanted a second verification of a signature. And that's what alarmed me, and so I came up with an alternative. You don't need any of this. I mean, there's a process. When they come in, program will verify that the signature on the page is a producer and count, make the count. So I don't know that you need any of this, any of the three.
It's a felony to forge your name on a petition, isn't it?
Yes, it is.
Yeah, thank you very much. That should be enough there.
Well, with that, I'd like to make a motion, can I, on these two first bullet points? I'd like to move that we accept these first two bullet points into the document as is.
I'll second that.
Moved and supported. And you're talking about the first two on this page of 3.
Yeah, the ones that were just highlighted right there. I feel like, well, it's above and beyond what has been done in the past, but I think it also validates what we're trying to accomplish here. And I think I could have confidence in what's getting done. And so does that third bullet point need to be in the process?
It's already there. This is in addition to the third bullet point.
No, you can't, they're gonna contradict each other. So you either pick, if you pick the third one, then, you have to, I guess you could pick the,
Okay.
you could also do the first one, but there's problems with that third one, and if you select that,
You
it's
answered my question.
very risky.
Yeah, because I wanted to strike the third one if we took these first two.
Well, why is it risky if we do whatever we want to do? I don't understand that.
Okay, so I'll give you a scenario so that, and I ran this through with the program. So if you implement the third one that requires the program to send out a letter with a stamped envelope and says, you must confirm your signature. And I'm Tony Dias, and I'm visiting family in the Azores, and I don't get my letter. And I'm my first vacation in 20 years. I don't get my letter, and I don't send it back. But I did sign the petition. Well, when the program doesn't get it back, they scratch his name, and his signature's been invalidated. There's no legal basis for you to do that. So there could be all kinds of reasons that people don't send it back. It could just be some ornery dairyman that says, I don't have to validate my name. I signed the petition. That should be good enough for you. You better count it. If you get enough of those that are just ornery or on vacation or sick, and you just start scratching off names off of that petition without any real legal authority to do so or any basis to know why you didn't get that back, and you fall below the 25%, if you started out above and you fall below and you say, sorry, you didn't hit you'll be in court. And you'll have to be defending yourself as to what authority you had to invalidate somebody's signature on a petition.
Okay, I was confused, because I thought you said we had the ability to do whatever we wanted to do.
Nobody has the ability to do whatever they want to do. I mean, you can put provisions in here, but you can put it in here. If you want to put it in here, you can do that. But if you're unreasonable or if you take legal risk, then you do it, but you're going to end up in court. And you're not going to be able to defend that action.
We could make the same argument about the referendum then, because those are mailed out and somebody might not get it, the mail might lose it. So what
Well,
happens then?
Don can probably address referendums, because we've had plenty of referendums in the department.
When we did the referendum for the QUIP, we did get phone calls from producers that said, hey, I didn't receive my referendum, and so we would send out duplicate or replacement ballots. And so what we found was producers, we would have a ranch address that we thought was also a mailing address, but it's out in the middle of nowhere and nothing gets delivered there, or if it goes in the box, it gets stolen. So we mailed a lot of ballots, or I should say a number of ballots to post office boxes rather than the mailing addresses that we thought were valid addresses on file. So as producers learn that there's a referendum in process, they start looking for those ballots, and if they don't get them, they certainly can call us and we can replace that.
Well, the same could apply to this then.
This is the
Well-
ballot, though.
This isn't a ballot, it's a petition.
That's, yeah, it's a little bit different.
Well, let's say you get to the referendum point. Let's say you get past the 25%. So I think he's asking, will you manage that vote the same way that you just described, as you just described?
Is that your question, Case?
The question is that if somebody would say that they didn't get their mail and they didn't return it, then their vote would be scratched. But the same could happen to in a referendum type scenario. It's just a different procedure.
Except that with the petition,
Called, you're not going to send them a new ballot.
but see, with the petition, they've already signed something. See, with the referendum, they haven't. They're getting it right first. With the petition, it's already been signed, and you're questioning that signature.
One of the
is
things that happened on the referendum, though, that I'm completely opposed to is we don't get notified of who voted and who didn't. My vote could have got lost in the mail, it could have been thrown in a trash can, and we don't know. So we lose by one vote, and my vote didn't get there. And I don't understand why we aren't informed if we don't, not how they voted, but who voted should be mandatory on there, that we know who's eligible to vote and who does vote. Because if we're short 10 ballots, they got lost somewhere.
The discussion is on the petition and verification of signatures. Let's get back to that.
Very good.
I have one question on, and this is of Don, and the partnership issue came up. Is there a question you can put on this petition or demand that every partnership has legal ability of a person to sign or two? I mean, how do you designate that only the legal signatory of a partnership can sign? The 10% ownership, you can't sign. I mean, that's,
What defines ownership?
yeah.
How about a DBA? Do they have to present a DBA to let them know who is the owner actually of a dairy that has a name other than a family name?
So when we have a DBA, the nice thing about the petition process we've used in the past is that we have the DBA, the business name, the address, we have your production, and so we're able to provide some information on that ballot that is sent out that we can verify that this went to that business address. If somebody were to sign on behalf of that partnership and we got it back and had reason to doubt that that person was the one that should be signing, we can follow up and ask questions, and we did do that in a couple in ballots on the QUIP process. But obviously, we don't have a listing of every partnership for every farm in the state. You know, we do have, again, if a producer owns quota, then we have the quota transfer applications or something on file that shows who is the owners of that dairy. But for farms that don't have any quota, we don't have that same documentation on file. We have very little, no information on that we can compare signatures or owner names to.
Donald, another question. There's just one vote per quota holder?
So it would be based on the definition of a producer. And so if let's say you're a partnership of yourself and one son, and you operate 2 dairies, that would be 1 vote. If you're in a partnership with another son and you operate 3 separate dairies, that would be another vote. So each different partnership tax identification number would be a separate vote.
So remember that these are recommendations. This is direction to someone who wants to submit a petition.
Yep.
If you get a petition and it doesn't meet all of these requirements, right? It's just enough for you to know that this is a petition, that you want to go forward with a referendum, and it has the signatures, right? So reading it, program, Dawn and the team, they know that this is a petition, but it doesn't meet all these bullet points. My advice to them is that they can't reject that petition. Again, these are guidelines, right? But it's not in statute or in regulation. So this is trying to help somebody put together a petition if they choose to do so, but they're not going to be able to throw one out because you didn't hit bullet 3, so you're out. Yeah, my advice to them would be you're going to have to consider this petition.
Any more discussion?
I just want to touch on one distinction. Council mentioned that in the past, when we've received petitions, we haven't had any issues. A big difference between what we're talking about today versus petitions in the past is petitions in the past could come from anybody. They could be an anonymous person submitting those petitions, and there was no threshold as far as numbers. It could just be one individual submitting something. Hey, Madam Secretary, we think you should consider X, Y, or Z. What we're talking about today is meeting a 25% threshold that forces the secretary to do something and moving it from the may to the shall. And that is something unique in that while those provisions have always been on the books, in my memory, which is fading faster and faster, we've not been forced into the shall section of the code.
Being that we're using the public and the dairies to authenticate that the people signing the petition are authorized to sign, does there need to be an additional public comment period for us to, you post it on your website, the public has a set amount of time to look over that and get back to the state whether they think there's fraud or not? Is that something you guys?
Well, I know it requires it to be posted, correct? If I remember correctly.
I believe so, but
But I'm not sure that there's a period of time. I don't think you asked for public comment on it.
No.
No.
but what I'm getting at is this, if there's, you're relying on us to authenticate it, so I would think that we need some amount of time to review the list and see that we think
We're
that
relying
it's.
on the staff to authenticate it. You can look at it and make a complaint.
They're relying on us to authenticate it also.
And the second bullet point here that we're trying to approve is relying on the producers to say, hey, if we see there's any I can't even say that word, but if there's any tiny bit of fraud, that they're due to report it. So I think, is that what you're asking?
Yes, that's exactly what I'm asking. Do we need a time period to review it and get back to the state on whether we thought there was fraud or not?
Donald, another question I got is, are you using pool certificate numbers for votes?
Let me come back. Jared, your question hasn't been answered yet, correct?
No.
So you could do that today. You could amend this language that talks about, it's at the bottom of the page, thank you, Candace, that talks about posting it on the CDFA website. You might add language in there, for comment for 30 days, or, you can insert something like that. Now, if you felt like it needed to be there and available for a comment or a challenge for a certain period of time. That doesn't stop program from validating, so it doesn't stop the process. It means while the team starts validating signatures, if somebody is out there reading it saying, that's not my signature, you know, they would have that 30 days or whatever length of time you choose to then notify the department or a lawyer.
What I was asking, in your legal opinion, is that something we should
I
put in here?
think that's a good idea.
Okay.
Yeah.
Just as
I
a
think it's 21
reminder,
days I think it's 21 days in the regs. Yeah,
as
it's 21 days to determine.
As a reminder, in December, the timeframes that were identified was after the petition is received, within 21 days, the department would start the certification process, which is the bullet 3, and then there's a 30-day period for the response. And then after that 30 days, I think within 90 days, the department had to certify the petition. So the way it's written now, there's an approximate 90-day window for the certification process, the response from the producers back to the department, and then for the department to go through and evaluate the signatures and the information provided. So, but as General Counsel mentioned, yeah, if there was, we can amend the language to say, or to clarify that while it's being posted on the website, if there's comments, concerns, that they can be addressed to the department.
You good? Ari, back to your question.
Yeah.
Do we use the pool certificate numbers? We do. When we put the ballots together to send out for the referendum process, we put a control number, if you will, and then below that, we put the pool certificates that we are combining onto that ballot and then send that out. So when the producer would receive their ballot, it would say Hollandia Dairy, and then 1, 2, 3, however many pool certificates we have assigned to that producer.
So he'll still only have one vote then, no matter how many pool certificates he has?
That's correct.
Okay.
Do all dairymen have numbers? If they've never had,
All grade A producers have a pool certificate number, yes.
number?
Yep.
Whether they're, have quota or not?
That's correct, yeah.
If it gets to a referendum, does a referendum drafted by this committee and then approved by this committee and then presented to the secretary for approval and then a vote by the producers? Is that the process?
So when we submitted we submitted the quota implementation plan to referendum, and we included that plan in with the ballot. And so as we drafted that, basically we took some input, but it's primarily the department drafting that. But if this board thinks that a ballot should be worded in a certain way, we certainly are open to the input.
Final product approved by the committee before it goes out, or that comes just out of the department?
And that would come out of the department. When the secretary takes recommendations from this board, she puts heavy weight on the recommendation from the industry, but if there's some purpose or something that, and I'm trying to think of why she would or we would, if there's something that doesn't meet the legal standard or something to that extent, why we would change the wording or verbiage that you may want us to put on that ballot, it probably would be based on what your input was. If the industry, or excuse me, if this board felt strongly that it should be worded in a certain exact way. all through this process, the secretary has been it's been her desire for industry self-determination. And so to the extent that your input meets the legal threshold, and that absolutely has been her desire, is to let the industry lead the way.
Any more discussion on the motion?
Sorry, just for clarification, is there any time period that those signatures are put on the website? Is that 30 days or is it 90 days? Just
I don't
for
recall
clarification.
right
Apparently,
offhand.
it doesn't say that.
Okay.
That was raised earlier, so you might want to think about that. A time frame that you think would give folks enough time to review it and comment on it, yeah.
So Fred, at this point, you have a motion and a second on the table to move the highlighted text into the document.
Correct.
But there was also a recommendation or comment from a board member that you would like to see a number of days put in there, that the posting would be out for a certain amount of time before we hold a hearing.
Which would be the first clause of the second, third bullet.
Don, I think under receipt of a petition, it says the secretary shall notify the petitioner in writing of its receipt. And then the second bullet is the secretary shall notify the producer review board of its receipt via email and post the petition on the CDFA website. And then it says the QUIP administrator will begin the verification process, et cetera. So there is there it is, right, so.
So you can, in the second bullet, you can extend the first sentence where it says, post the petition on the CDFA website, and then for no less than X days, at which time it will accept public comment on the petition. So it would be up to you guys to figure out what you think is reasonable and fair for producers and the public to go on and view that.
To post the petition with its signatures on the CDFA website.
With signatures?
That's my proposal. I mean,
Well, let's, what 25%, how many signatures do you think that would be? I mean,
Around 250.
Around 250. So if somebody wanted to look at those signatures, right, it wouldn't take, how long is it going to take to look at 250 signatures? And I mean, a person could go out and contact them and say, did you really sign this? You don't know what's going to happen. Once it's out there, it's out there. So 250 signatures is not a lot. So how much time would it take for somebody to review that and do whatever they wanted to do with it?
Don't you have to get back from your once in 20-year vacation from the Azores?
I know.
I mean,
Injunction to hold our money paying out, or delay in the process, I think that'd be fair. We go 90 days if you want, as long as we don't have to keep paying that 90 days.
Yeah.
Put it in escrow account.
I mean, it wouldn't, it's not going to stop the process that's happening internally, because the team is still verifying those signatures, right? So that's happening while they have their comment.
Yeah,
So,
and wouldn't they report if they think it's a fraud? Wouldn't they go to the district attorney? Why would you even come to these guys here? Throw the guy in jail who's frauding on a signature.
It might not be a fraud, it might just be unauthentic, I mean, but you have 90 days, so what if we said, and it's not gonna slow it down, what if we said 60 days?
yeah, whatever, it's your call.
I think that was said 21 days, didn't it? In original writings, 21 days, but if we extend it longer than that, I think we should talk about it.
21 days was a bullet that we're throwing
Days
out.
yeah, the department needs to start the certification process within 21 days of receipt.
and you're gonna be at that for a while, so I think 60 days is okay too.
So when you say
this will be going on, looking for, quote-unquote fraud while staff is doing their job. How long does staff need?
Good question.
The way it's written right now is, I believe it says within 90 days of receipt of the petition.
So I think if they're gonna work side by side, then if staff needs 90 days, then it should be 90 days to look for fraud. I mean, if they're gonna go side and side, to me, that makes sense.
And so you're putting this out there for the industry to review.
Yeah, I'm only commenting on what the council said about both things would be going on at the same time. So if staff feels that they need 90 days, then I think 90 days is the number.
Works for me too.
You want to amend the motion?
Yeah,
It's on the
amend the
table.
motion. Put 90 days.
Got a support?
I second.
You didn't move or the
Yeah,
motion
isn't this in a different part of the document? Why don't we just,
Yeah,
why
this,
don't we just
this,
put these 2 bullet points in and then vote on, make a new motion on this one, on the
that's correct. So that this is different than the 2 bullet points that the motion addressed earlier.
Isn't the sentence added to the 2 bullet points?
No, we ended up putting it at different,
Okay.
different paragraph.
Thought you were going to friends already.
Yeah,
Okay, so we still have the motion on the table of the first 2 bullet points,
yep,
unchanged, as written.
Yep.
Any more discussion?
hang on. So before you take any action,
Oh,
we have,
comment.
public has the opportunity to comment and have public input on
does the
that.
public, any of the public have input on the motion?
So if anybody would like to speak, make public comments, the microphone is in the front and center. Come on up and make your comments to the board.
Good morning. My name's Kristen Hagan. I'm a lawyer that has been retained and is advising a coalition of dairymen that is interested in pursuing a petition to terminate the QIP. And I do have several comments, some of which don't specifically pertain to the particular issue that you are addressing currently, but to the draft procedures overall. So I presume would be the proper time to address all of those.
We would do that at a later time.
So
Right now, it's comments on the motion.
Then I will specifically address the particular motion, and then when it's appropriate, I will come back up and address the rest of my
Perfect.
issues. So as it pertains to the issue that's on the table with respect to verification of the signatures and the suggestion that those signatures be notarized, I would question the ability to impose that additional requirement because at the time the standalone program was implemented after the federal milk marketing order was adopted, that was not a requirement that was in place. So here we are roughly, approximately 2 years later, and we are changing the name of the game. Changing the procedures, changing the requirements that will need to be met in order to first overcome the petition requirements and then send it on to a vote by way of a referendum. So I would simply question the basis for that and being able to amend the QIP at the board level in what I would argue is a substantive way without making that amendment pursuant to the referendum process as is required. Thank you.
Can I address that, since that was my language about the, so just to be clear, that is not meant to be a requirement or even a recommendation. One of the staff had asked me, what if you get signatures and they're notarized? And I said, well, those, if they're notarized, those would be deemed valid, so we added it on there. But hearing that comment then raises some concern that people might read that as a requirement, so you don't really need that first bullet, and you may not want to even include it on there, because we've been discussing this in the meeting and there's still some confusion, and so we wouldn't want to have additional confusion. It doesn't really add anything to the process if you got signatures notified, they'd be deemed valid. You don't need to have a bullet point on there to say that. So you might consider eliminating that bullet to eliminate any confusion that it's a requirement.
Okay, question on that, then the second bullet point, is that acceptable then? Confirm the validity of all petition signatures, except those that have been verified by a notary that the petition was signed. Leave that in there, in the second point, second bullet.
The department will take reasonable steps to confirm. So that would be your choice if you want to leave that in there or not, because when you discuss it in the second bullet, it's within the context of a review,
Yes.
right? That, or a challenge to the signatures. Or you can take it out if you think it's confusing there. You guys can remove it there, but
My opinion is not confusing, your point is it's in the review process, but up to the maker of the motion, you want to eliminate the first bullet point?
Yeah, if that's what everybody's flavor is, but in the end, I read the second one, and I assumed that the original signatures was enough, or the signature was enough without the notary.
I actually read it wrong. I was under the understanding that it was a requirement. She made the comment that if we're changing it, that would raise legal issues. I thought we're coming up with a brand-new set of rules. Are we changing something? If we do make it a requirement, do you recommend against making it a requirement?
I do recommend against making it a requirement. It becomes burdensome then, I think, and expensive for someone to collect those signatures.
Okay,
You know, it seems that if you're going to remove the first bullet point, that the language that's highlighted now could easily be removed too, to make everything flow better.
you could, but do you need to?
You don't need to do anything. It's good the way it is.
The second one is fine, in my opinion, but,
First one's fine too,
well,
yeah,
So
nothing wrong with that.
Basically, these two bullet points, in my interpretation, is that they bring the fraud aspect into play. If there is fraud, then this kicks in. But other than that, we're going along the original procedures, how any referendum or petition is signed by a producer and verified by the department. Is that correct?
Yeah, but you don't want to have any confusion about, you don't want anyone that wants to submit a petition to be confused, and that's the concern with the first bullet.
So far, the only person confused was that lawyer.
Well, everybody hasn't seen it yet, though.
That's not true there, Ari, come on.
the second one is where the department has to confirm the validity of all petition signatures. I mean, however they do it, we're not telling them how to do it. But then the next one, if they're notarized, they're valid.
Yeah.
I think that's my opinion. It's fine.
I agree.
But the first, I agree, I would go along, I could go along with eliminating that first bullet point.
Okay, well, I'll strike that as if the second maker of the motion.
Second.
We'll do that.
Okay. So the motion on the floor now is bullet point number 2. Is there any more discussion? Hearing none? All in favor, aye?
Aye.
Aye.
Opposed?
Oppose.
One opposed. Motion passed.
Can you oppose that, man?
Do you want a roll call vote?
It's up to you.
I don't.
Steve, any input on roll call versus non-roll call?
It's pretty simple, isn't it? 10 against 1 on all the votes?
Yeah, Craig Gordon was a no.
Just write me a consistent no. I want to stay with the laws of California.
Fred, what I did is I copied that second bullet into the document that you have, the double-sided one.
What's that?
So it replaces that one line that says, we'll talk about it at the meeting. So that's what's up there. Based on your motion.
So-
passing.
Okay,
No, it's been put into this document.
into this one, yeah. So is there any other,
So the other thing that I had done
So that takes care of that bullet point. There was also discussion on the number of days to post, and that was in this procedure document. So we still need to, the board still needs to decide what they want to do with that discussion. I think that was like a bullet point 3 or so.
Right there. So I added signatures, 90 days, just to hold that, because that's what the second motion was about.
So just to revisit this, this was based on a board member's recommendation that the signatures, the petition with the signatures needed to be posted on the department's website for a minimum length of time before we took further action.
I'll make that a motion.
I'll second it.
Moved and seconded. Any more discussions?
So Will has made a motion to add the 90-day provision. Ari has seconded. Again, before the board takes any action, opportunity for public comment.
Public comment on that issue.
Okay.
They like it.
Yeah. No comment. No further discussion? All in favor of the motion? Aye.
Aye.
Opposed?
I oppose it.
One opposed. Motion passed.
Okay, so that takes care of that.
I just have a tough job. Keeping everybody on that straight and narrow.
So now that we have the revised draft document, has been amended since the 19th. It now includes that 90-day provision. It also includes the bullet point that was recommended by council. Is there any other amendments that were made to this document?
Yeah, what I would probably do is go back to the beginning of the new document and just going through the document. And in the back of the auditorium, and I believe we provided the December 2018 document, and we have a copy of the February 2019 document. So you can go back and compare the two, but it might be good to go through the entire document now just to make sure that there's a review of the new document and any discussion by the board and any public input in regards to the document. Does everybody have a copy of the December version?
I have
It should
a
say
few
December
copies of the December. I don't have a February, as you say.
Yeah, one says the working draft as developed by the producer review board at the December 19th, 2018 meeting. It says working draft, that's the December one. And the other one is a revised draft.
This one here is your December 19th, and this is the one that we're looking at today. Yes, this was amended, and we now have this. So the revised draft is what we're looking at. And so we just moved the bullet points into this revised draft.
Revised.
Yeah.
He said February, and I didn't see a February on there.
Yeah, it doesn't say February. Okay, so we just want to work down through here. Some of the bullet points have been tweaked a little bit. So bullet point 1 that we had in December, the first bullet point, a brief description of the request changes, including a copy of the suggested language to amend the plan. If you look at the version we're working on now that has been expanded, the first bullet point says the name and contact information for a representative of the petitioning party. Second bullet point, a brief description of the proposed changes, including a copy of the suggested language to amend the plan. So that bullet point has, well, we added that first bullet point to get the name and the contact information, to be specific that we needed that. And that's one change. One thing that was brought to the attention on the petition shall be submitted in one package to the CDFA. It says to email that to myself. Was suggested that maybe we would be better served if we used a generic email address that we have for the department. We have 2 generic email addresses that we use to receive information from industry, or for anybody for that matter. We have one that is dairy@cdfa.ca.gov or pooling@cdfa.ca.gov. I'd end up receiving both of those emails as well. But thoughts are if we use dairy, then less chance of it getting lost. Spelling Schipholhood is not always the easiest thing, as I learned early in life. So if we went with dairy, we would eliminate potential issues there. And when it comes in, it would be forwarded to multiple staff instead of just myself, and again, don't have to worry about spelling errors. I'm okay with that.
Yeah.
Any thoughts on that? Any preference there?
So what's highlighted, you change.
Yeah. That, it's highlighted because it's a link. And so we just strike that to get rid of my name and go with dairy at cdfa.ca.gov.
Want to take out your name, say the administrator, whoever that administrator would be?
I'm okay with that.
What's wrong with dairy?
Nothing.
Yeah.
No, but she's talking about the line above where it says to submit it in one package to the secretary or the QUIP administrator.
Oh, yeah.
She's just saying, just whoever the QUIP administrator happens to be
Okay.
at the time. It's highlighted and hit delete. And delete again. There we go. Do not. It's not the immortality here I'm worried about. Hate mail. Yeah, I get enough of that hate mail already. Okay, scrolling on down.
I think, Don, one thing that was added toward the end is if the petitioner withdraws the petition, they may resubmit a new petition. That was something that was added.
Okay.
And I believe the other one thing was to be considered a complete package. The package shall include all the above items. So at the very bottom, it's on the screen, it's the first bullet to be considered a complete package and the third bullet. Those were added for clarity to anybody who would submit a petition. Because somebody may say, oops, I want to withdraw it. And the question was, can they resubmit it? And the answer was yes, they should be able to resubmit.
Okay.
So that's a recommended change to the revised draft.
Yes, the one from December, yes, the to be considered a complete package. Candace, can you highlight that one, to be considered? That one was added, and then the one if the petition withdraws the petition, they may resubmit. So those have been added just for clarity and
All right, and I am working partly blind here. There must be a second page, which I don't have in front of me.
On the working one?
On the revised draft. The working one I have front and back. The revised draft, I only have the first page. That's not public comment, is it? All right, so the second page. Jeff, was there any changes there that you were referencing, or we good?
testing, okay. The one thing that I believe also that was changed, I'm just sort of looking through made some notes this morning. Candace, can you scroll down? The secretary shall notify the petitioner. That is still the same. The secretary shall notify for no less, that's the one you just modified, the second bullet that's on the screen. Right, that's the, right. Right. There was a slight change on the next one that says the QIP administrator shall verify all dairy ownership. So we sort of clarified, because I think we had verify all information, and we changed that to all dairy ownership. So right there in the top bullet, Candace, where it says all dairy ownership, yeah, that's where it was changed. It used to say all information. And what we did is we said all dairy ownership using the latest QIP program producer information. So we just changed the word from information to dairy ownership. And that was just for clarity. The next bullet down where it says the QIP administrator shall tabulate. One thing that was added is the last sentence. Candace, can you just highlight the last, where it says if the response rate? In the third sentence, or third line, yep, that and down. And one more, just finish the paragraph. We did clarify that if the response rate to the certification process does not achieve, but if we remove the certification process, does that need to be deleted? That may be the question. Because if we remove the certification process by the first motion that was made, this part may not need to be added.
And you're talking about the paragraph.
Yeah, that is now moot, because if we've deleted the certification process, then that can be, at least my sense is that can be deleted. But I want to make sure the board understands before we hit the delete button.
That was tying back to that verification process that was the third bullet on here
Yep.
that we weren't using.
Can you, oh, yeah.
So that would be struck out.
Or would you change it to the response, indicates not the required 25%. You're verifying signatures, and you're verifying if you have 25%.
We'd still be verifying 25%.
Yeah.
Yeah, good point.
Seems the petitioner wouldn't turn it in unless he knew he had the 25%.
So there's,
It'd be a moot point to do that.
so that goes back to Craig's earlier question, and that is, how many producers are there? And so while we know how many dairy farms there are in any given month, without much effort, I mean, we have a report that shows how much milk by farm, but then when we go through and decide how many, or determine how many producers that represents, that's a whole different story. And so I've been asked a number of times, how many producers are there that would be eligible to vote in a referendum if it was held today? That's not as easy as just going to the database and pushing a button. That's a lot of manual time going through and looking at business names, business structure, and trying to combine those numbers together. So it's a multi-day task to go through that. We did that when we did the quota referendum. At that time, as I mentioned earlier, we had about 40 staff, and so we had people that we could tap into to help do that every month if we needed to. We just don't have that staffing to do it. If we get the referendum, I mean, somebody asked me how many we have, I say roughly 1,000. I think there was 1,050 or 1,060 in the QUIP. I can give you a rough number today, but I can't give an exact number.
So when it comes to a petition, you would look at the exact number, and then, let's say there was 2 signatures, one from 2 dairies that were under this same ownership, you would disqualify one of them in the petition process?
We would only accept one per producer, yeah.
What you could do is that sentence that is highlighted, you could change it to identify that if the 25% is not achieved, then the petition would be deemed invalid or something to that effect. Because that particular paragraph talks about the QUIP administrator ensuring that the petition is valid against its own records. And if the program identified that that process was not met or achieved, the 25%, then the petition would be deemed invalid. So you may be able to change that first part of the sentence.
That's what I was trying to get at a while ago.
Right,
yeah.
and whatever language the board would like, but, yeah, it's. And I think the petitioner may resubmit another petition, I think is still very valid and reasonable. So you could say if the department cannot, let's see, just went blank, oops. Candace, I think you jumped. Oh, backspace. The joy of Word. Okay. Make sure you're keeping up with us. There we go. Yeah. If the department is, cannot validate the 25% signature threshold, then the petition is deemed invalid. And then you would delete. Keep going to the comma. Yep, keep going, almost. That's just perfect. And I think you have a double "the" at the beginning of the sentence, if the department.
Don't have the in there.
Yeah, and that wording can be modified if the board would like, but I think that's the general idea is that if the department cannot validate the dairy information and the signature, then the petition would be deemed invalid, but the petitioner still may resubmit another petition. You might be able to say, you may be able to clarify that it's just not the signature threshold, but it's the producer information too. So
I
you're
think
not just
the
tying.
language we have in things is petition and writing indicating why the secretary has reached such a decision on the merits of the petition. She can deny that. It hasn't met all the things that are supposed to be in there. The signature's got to be right. The petition has to have certain things as far as describing, the language, at least here we have in here, the California Code of Regulations on mandatory to amend or terminate stabilization and marketing plans on the milk pooling plan under section 62717 Agriculture Code. It lays it all right out there, what you have in the stuff, the brief description of requested changes, including a copy of the suggested language to amend the plan or terminate, specifications why the petitioner recommends the proposed changes, the authority of the secretary to take the action requested, and then it goes through the whole process here. I thought we were operating under that. So if there's not enough signatures, she can deny the petition.
That's correct. If there's not enough signatures, then her action is a may, not a shall.
Yeah, and they have on here the time limit of 15 days and then 60 days if there's a question to it, as far as getting it to the actual referendum. And it's spelled under the codes that we quoted at the last meeting. That's 62717, 62705 comes off that 3.5, which you talked about earlier.
And so you're reading language out of the California Code of Regulations right now. And so those codes of regulation were adopted under chapters 2 and chapters 3 of the code. So I don't believe they reference the supporting language for the QUIP that authorizes us to have a separate standalone quota program.
I came under
I guess,
3.5.
so the challenge of citing the CCRs is that they have to point back to a supporting section of Food and Ag Code. And the section of Food and Ag Code that authorizes a standalone quota program was not referenced in there.
Is that referenced in the QIP?
The QIP was created under that authority.
And is that written on the QIP document?
I don't recall that.
Where does that say that at again? Under the QIP? Okay.
You have that up on the screen too, I believe, Candace, right?
Sorry, this is a PDF, so.
Candace, I think that's the order of the secretary. I think it's the next page. But the background also identifies that. And then it's the very first page, right above definitions, right above Article 1.
Yeah, section 62757, the Food Ag Code. What I just
Right
read was
there.
underneath that code.
Any other comments? Okay, so that change was made. So again, if the number of votes is below the 25%, the secretary's action is a may as opposed to a shall if you get over that 25%. All right, so getting,
Can the petitioner, just, if he's gonna wanna skip this here, say, we'll grant the 11 no against this petition or not recommending it and 1 in favor of it? Since we get a mandatory hearing, can we just propose that instead of wasting time coming here and hearing all these guys, say they don't want it? We can just tell the secretary that they're all not gonna recommend it. So can we just skip this process?
I couldn't hear the whole what you were trying to say.
Well, what I was saying is we get a if we have 25%, it mandates, it triggers a mandatory referendum. My question is, why are we even bringing it here to producer review? Can we go ahead and stipulate that it's the producer review board, 15-1, don't recommend aren't happy about the referendum? We're gonna go to vote anyway, so what's the purpose of even coming here?
The QUIP program that we adopted says the 25% petition has to come to the producer review board for hearing.
That's
The
why I
producer
understand.
review board then has to make a recommendation to the secretary. That's what it is. We can't change that.
But can we stipulate that the producer review board doesn't recommend it?
No.
Okay.
okay, so going back then to the revised draft document, which is the one that we are amending today for your action on. Looking through the other changes, we talked about the 25% threshold. If the threshold is achieved, then the secretary shall schedule a meeting of the producer review board within 60 days of petition certification. The producer review board shall review the petition in 1 or more meetings, adopt findings, and make recommendations to the secretary. The secretary shall review the PRB recommendation, and if the secretary finds that the plan no longer tends to effectuate the purpose intended, the petition shall be submitted for referendum in the same manner as provided for its initial approval per Food and Ag Code 62755.
And Don, that is a new paragraph. We added clarification language. We tied it back to what's in the QUIP. And because 62755 is in chapter 3.5, which is where the QUIP resides, that entire paragraph that Don just read, the one at the very top of the screen, was added.
Is what?
It was added. That was new. And we tied that back to the language in the QUIP, and we wanted to ensure that the initial referendum was identified in 62755, so we just clarified that.
And the next bullet, the secretary's determination shall be reported to the petitioner, the producer review board, affected producers, and posted on the CDFA website within 30 calendar days of the producer review board's recommendation. And finally, within 45 days of the secretary's determination, CDFA will initiate the referendum process in the same manner as provided for the QUIP's initial approval.
And that is also a new addition. The last bullet, the secretary asked, well, after, if I make a decision, when does the referendum start? So we made it clarified that within 45 days of the determination. So the first bullet that you see at the top of the page and the last bullet are new. And they were added for clarity and for confirming timeframes.
Just a question, if it might be helpful to have all those bullets identified with a number or a letter so that we are sure we're on the right one when we talk about bullets. In the future, is that possible?
We talked about that, like if 1, 2, 3, 4, then people think it's sequential, and it's sort of sequential, but not necessarily. But if it helps to clarify discussion, we can certainly number it, or however you would like us to identify it, certainly.
Fred?
Okay.
One more question or thought. If a petition comes back, and it goes to secretary sends it here back to this board, and it's I'm making it up, 20-page document. Does this board have the potential that we could revise some of the language in that petition before we send it back to the secretary, or do we have to approve it as is, yes or no vote?
The petition is a petition. If somebody in the industry submits a petition, that's their petition, and that's what they're asking for. If you, as a board, want to make a recommendation to the secretary saying, "Hey, we liked all 19 pages of this petition, but we want to, page 20, we don't like it," you could rewrite page 20. That would be a separate document, and you could recommend to the secretary, "Madam Secretary, here's a petition as it came in. Our recommendation is that, it's flawed for these reasons. We recommend you take action on this document. And here's a new petition, if you will, or new recommendation for you to consider." But yeah, we wouldn't have the authority to amend any incoming document before it went, yeah, yes.
I lost my agenda. Here it is. That's mine.
You gotta keep an eye on it.
Yeah. Are we,
So,
Any-
go ahead.
any more comments on the whole redraft? Are we finished with the changes, recommended changes?
I don't have any recommended changes. The board members don't have any recommended changes. Good opportunity to accept public comment.
Oh, yeah. So we can have a public comment on the entire draft at this point.
Rob Van Hevel with California Dairies. A couple of clarifications. For starters, this is the first time we're seeing reference to section 62755 as the rules of the referendum. I think we ought to get legal counsel's opinion on whether that's the appropriate, because that is not the same set of rules that were in place to approve the QIP. This is for a continuation vote. So I want to make sure you don't approve a document that's pointing to a section that's not the right set of rules for the vote. The other comment I would have, and this is as someone who interacts with a lot of producers throughout the day with a lot of questions, this document is somewhat vague on what this, in fact, in this discussion today, the discussion has been vague in terms of what the secretary's options are. I've heard as far as she shall conduct a referendum to she shall conduct a hearing. And I don't know if this committee wants to add some clarification or if it's vague on purpose. But for instance, we've held many milk hearings over the years where alternative proposals are allowed to be considered, and the secretary can find a determination that has some variation from the original hearing petition or hearing request. And so either clarification from legal counsel or discussion from this board would be helpful for those of us who are talking to producers about, okay, if this petition is submitted, does that mean it's a yes or no on that petition, or is there a process by which other issues may be debated? And so that would be very helpful for the industry to know what the secretary's discretion actually is. So those are my two comments. Thanks.
Thank you, Rob.
Hi, Lucas Denise from Denise Dairy in Petaluma. I have a question. I'm looking at the revised draft paper that was back there, and one of the bullet points on the bottom of the page here says, if the petitioner withdraws the petition, they may resubmit a new petition. So my question is, how do you resubmit a new petition? Can we have some clarity on that? It's either a new petition or it's not. So if you withdraw it, are you making changes to it? Are you making amendments? And then are those signatures that were on the original petition valid? It would seem to me if you're going to make changes, then you'd have to go back and get new signatures for this petition. So I think that section needs a lot of clarity. It's either a new petition or it's not. It's not, you're either resubmitting the same one or it's a new petition. Can we get a little clarity on that issue?
Let's keep going, and we'll come back and hit those.
Okay, Lance Mao from Riverbend area in Tulare. So I have a question. If you add up all your numbers on your days, maximum amount of days is about 225 days before you would have a response. Once you go through the process, right, then you would start the referendum. But one thing it says on there is that this board can review it one or more times. I mean, what's one or more mean? You can review it 10 times? And if you only meet once every 6 months, so that means it could take 5 years. That's pretty open-ended, one or more. What would determine whether it's 2 meetings or 7 meetings or 12 meetings? So, and then if Secretary Ross decides that this board is moving too slow, can she just say, you know what, you've had it this long, I'm moving forward? Is this board advisory? I know it's advisory, but does she typically always follow the board, or can she say, I don't think the board is doing the producer's due process here, it's taking too long? Can she just say, you know what, we're moving forward without you? I'm new to the whole process, so I'm trying to understand, you know, how this all moves forward.
Can we answer that question or no? We'll answer it later on, Fred?
We'll have a discussion on the comments.
Okay.
You writing them all down?
Again, my name's Kristen Hagan, attorney for the coalition supporting termination of QIP. Thank you again for the opportunity to address you on a broader level with respect to my overall comments on the procedures. I'd like to state at the forefront that my clients, the coalition of dairymen that I'm advising, they're seeking to pursue a petition that's premised on rules that have been lawfully enacted. And they simply at the end of the day would like to pursue a petition based on a level playing field. And so based on that, I would urge this board and the department as a whole to act so as to ensure that the process is both fair and equitable. Some of the concerns that we have, and I have in particular with respect to the procedures that you're considering, I have some concern that some of the bullets move beyond simply being administrative type procedures, housekeeping procedures, if you will, that help guide and administer the receipt and processing of a petition, but actually contain substantive requirements against which these petitions will be judged. So for instance, the bullet that requires that specific justifications for the proposed changes, including legal authorities, relevant analysis, comments, and data supporting the request shall be submitted. Those are clearly substantive requirements, and quite frankly, it's vague in terms of what those requirements actually consist of and what would be required, what type of threshold would need to be met in order to satisfy those conditions. Also, clearly, I think I stated this earlier, but just to reiterate, what the QIP does currently provide under Section 1101 is that any substantive change to the program and the way it's administered, those changes must be made pursuant to a referendum process. Another concern or issue that I'd like to raise, it's with respect to the bullet that provides that this board shall make certain quote-unquote findings in connection with consideration of a petition. Again, no clear indication as to, one, what those findings are, or two, any guidance as to what would educate and guide your decision as to whether or not those findings have been met. And that clearly is a requirement, a substantive requirement, not simply an administrative type housekeeping requirement. Moreover, and this has been highlighted by others' comments, to the extent that the board is unable to make findings under that particular bullet, there's some confusion as to whether or not this board would have the authority to actually deny a petition on that basis. Any implication that you would have that ability, though, would definitely usurp the secretary's power under the statutory provisions that clearly dictate that the authority ultimately rests with her. The other issue that has been raised, I think, on a number of occasions this morning is with respect to how the votes would be counted. There are very specific statutory definitions of the terms producer and, in turn, quote-unquote person. I won't go into a dissertation of that analysis, but the bottom line is that each entity, whether that is an entity formed as a partnership, an LLC, a corporation, each entity producer, if you will, is in fact entitled to a vote under the statutory code. Based on that, I would just simply encourage this board to take a measured approach to this issue, and I do thank you for your time and consideration this morning.
Any other comment from the public?
Okay, so no other questions. Let's address the questions that have been raised. Mr. Denise asked about the bullet point on the bottom. If a petitioner withdraws, as the bullet point reads now, if the petitioner withdraws the petition, they may resubmit a new petition. And so his comment is that is a bit vague, causes some confusion. I think a very valid comment on his part. And perhaps that could be addressed simply by striking the word resubmit and just put they may submit, I'm sorry, instead of resubmit, they may submit a new petition. Yes.
Art. With the understanding that they have to go back and get new signatures to attach to the new petition.
That would be my understanding. I certainly, as a department person, wouldn't accept petition signatures that were dated from, as always commented, 4 years ago onto a document that was just drafted 6 months ago.
I think that's what the producer's question, he needed that answered, right? Does that include all new signatures?
Yeah.
It should.
If the petition fails, it fails. He has to start over again. You know, to take those existing signatures and then go back again, that negates what we said earlier, that you can't add signatures to the petition that once it's been submitted. So he'd have to start completely over again, or she.
And changing that from resubmit to submit, I think clarifies.
To submit a new petition.
Everybody always has the right to submit a petition. So we don't really even need to tell him that he has the right to submit a new petition. I mean, if he withdraws the petition fails also, right?
If he withdraws a petition, there's no petition to be considered.
Yeah. So, I mean, the whole bullet point can go away, really.
You can't have signatures that don't match what the petition says. If you change the petition, obviously you have to.
Once it's submitted, you can't change it. Once it fails, you can't resurrect it.
You can resubmit it for the same exact word if it fails, so why would you resubmit it?
The point is, you can't resubmit it, because then what you're doing is you're taking your old petition and you're saying, oh, shoot, I found out I didn't have enough signatures. Let me take the thing and then just add a few signatures and resubmit it. That doesn't work. If it fails, right? You can start over again. You can, anybody can make a petition at any time, but you can't use the signatures that were on that other petition and then just add to it. You can't add signatures to the petition.
Correct.
Anybody can always submit a petition.
No, they worked it out.
And I think you guys need to read the bullet above too, because that, it's kind of both things that you're talking about. So you can't amend a petition, right? And if for whatever reason, somebody had submitted a petition and then said, oh, I want to change, I'm going to withdraw it and resubmit it, they couldn't do that. Yeah. But I don't know, again, I don't know. I mean, it seems really obvious to us, but I don't know if that last bullet needs to be in here.
It doesn't.
I definitely, it can't, when it had the resubmit was a bit confusing, but. I mean, it's obvious, they could submit 100 petitions if they want. If they submit a petition, it fails, they could submit another petition. So it's kind of an obvious statement that if they withdraw or if they fail, they can submit a new petition. So I don't know, it seems obvious to us, and I don't know if having the bullet in there actually creates confusion.
I think it does. It did with him, and it did a little bit with me. The whole resubmitting is like, that's already a wrong word. Submitting a petition, I mean, you don't even have to be in the dairy business to submit a petition, right? So anybody can submit a petition at any time. So you can take the whole bullet point out as far as I'm concerned.
Make that a motion?
I'll make it a motion to take that last bullet point out.
I'll second that.
Any discussion?
Public comment.
Did somebody say no comment?
I asked for public comment. I didn't hear anything.
Okay,
My hearing is kind of with my memory, and they're both going, so what happened in the back of the room, I'm not sure.
is there any public comment on this particular motion? Nobody jumped up?
Okay.
No more discussion? All in favor, aye?
Aye.
Aye.
Opposed? Motion carried.
Okay, so next question from Mr. Mao. And I think this is a question for Michele. What is the secretary's authority? If the secretary thinks that the board is dragging its feet or taking too long to get through the process, what is her authority? What can she do about that?
Well, it's an advisory board, so the secretary can, if she thinks you're dragging your feet, she can call meetings, and bring you in here more often. Again, she will always consider your recommendations, but she has that independent authority. So I don't know if that answers the question or not, but
I'd like to answer for Lance, just give you an example what happened. She approved everything that we recommended on the QUIP program, but there was one that she wanted a 5-year review, which I made a motion to add that into the language. I didn't even get a second on the motion. And what happened when the thing came out? It was in there, because she has the right to throw that in, and she did. But other than that, she followed all the rest of the recommendations that the board made as far as an advisory board. But she has the power to put in what she wants to and take out what she wants. We're just advising her what we think she should do from the industry standard. We don't make policy.
To continue with that, does she also have the power to ignore a petition or ignore a referendum?
Not if you have 25%, she can't. If you have
Yeah.
underneath that, she can.
No, she's not going to ignore, no.
She doesn't have that power, or she wouldn't do that?
Well, I'd have to go back to the codes because this is under the QUIP. So I'd have to go back and look at the original code where it was in the trailer bill and connect it back to the FAC. But I'm going to say because she made findings and we have the QUIP program which allows for that, I'm going to say based on her own signing of those findings that she's committed herself to consider that. So based on her own findings, that she could not, she couldn't, and she wouldn't ignore it.
Once that petition is submitted, then can she amend that petition on her own? No.
No.
The secretary cannot.
No, I don't believe so. I think Dawn alluded to that, but I don't believe that the secretary can change a petition because you would be, then you're changing what people sign. So people put when they sign a petition, that's what they're voting on, so to speak, to get it out to referendum.
So if the petition was before this board and the board voted that we were not in favor of the petition, and we presented an alternative petition to the secretary, she would not have the authority to make a choice of the two?
Well, I think she could consider your alternative petition. Yes, she could. She could consider yours. But I think that the fact that if she received a petition with signatures, that would carry more weight than this board. Now, saying that she's not going to change a petition doesn't mean that she can't clean up some language. So depending on how the petition comes, but to make like major or substantive changes to a petition that was properly submitted and had the 25%.
In reference to that third to last bullet point, the 62755, I didn't know we had a question about that, the clarification on that.
So 62755 lays out the percentages. That's all about the percentages of the total number of eligible producers. So it lays out what, for the referendum portion, what percentages have to be met.
I can't remember the question, but are we allowed to reference that even though it's in a previous?
Yeah, it's in chapter 3.5.
Oh, it is 3.5.
Yeah, so we can reference that. Yeah.
My question was, do you see the sentence before 62755 in the same manner as provided in its initial approval? The initial approval didn't point to 62755, it pointed to 62716 and 62717, which is different language on the referendum. That was my question.
Okay,
Sorry,
so
should clarify.
So where the percentages, do you know why, I wasn't here at that meeting, do you know why you guys picked this code? Are these percentages different than the earlier selected there?
They are a bit different. I don't recall why we pointed to the percentages that we had in chapter 3. Seven 757, I don't have that printed out in here.
Let's see.
And for those of you that may not have heard Jeff's comments, he pointed out that the trailer bill that authorizes a standalone quota program points to the provisions in Chapter 3 for the implementation of a standalone
So
quota.
there is a difference. So 62717 starts with the 51% of the total number of eligible producers, and then it's 65% of the eligible producers who voted in the referendum, whereas it looks like 62755 is 51%, like straight across, which is a lower threshold. So I think it's probably inappropriate to reference a new code. You should stick with the code that was original, the 62717.
So we can't add things like we talked about earlier then? Why can't we just put that 6255 in?
Well, because it's going to be, it's inconsistent with what you did previously. So it's kind of like you're
And it's
in the middle.
it's inconsistent with the code as well.
Yeah.
So we should change that 755 there to reference 717.
That's the 50, 55, 65, 51,
5165, yeah.
I'm wondering if this was put in because this section 3.5, this chapter 3.5 is about pool quota production. And maybe that's why
I think you're exactly right.
it was selected, thinking it's more on point to what we're doing here with quota, but it does create a conflict with what was done earlier.
all the votes on pooling have been under that threshold, correct?
All the referendums for pooling were done under the provisions of 62717, that's correct. The provision in 62755 was put into law when we implemented the $1.70 spread, and it was put there with it gave the industry the ability to move away from the $1.70 spread and go back to the pre-$1.70 payout out of the pool, if they wanted to.
But it was still the same voting procedure.
The voting threshold is a little different. There are some mandatory provisions in there as well as to when a secretary would have to hold a referendum. Okay. All right, so we took care of Rob's question, I think. Lucas, Lance, and do you want to address Ms. Hagan's
The
comments or
questions about what's included in, so I don't disagree. I had mentioned before that this isn't in regulation. So this is direction. I think that this is my understanding from the earlier meeting was it was in hopes of getting a petition that was complete or had information to be reviewed by the board and by the secretary. But again, as I said earlier, if you didn't have all of this information and you received a petition and it had signatures, my advice would be to move forward on it and try to verify that those signatures were actually producers and move forward. You can't require this because this is being done here as guidelines and it's not in law and it's not in regulation. So you can just hope that somebody submits a very complete petition. And if they don't, you're going to have to consider it anyway.
Well, on that number 62717, by putting that number in there, does that mean on a referendum, it's a 2/3 majority to get a referendum to pass?
Is it?
Yes.
Let me go back and look
The
at.
62717 is 65%
Yeah.
with 50% of the milk, or 50% of the milk and 65% of the producers.
Of those who voted or of total producers?
That's a very good question. So the director shall find that the producers have assented to the plan if he finds on a statewide basis that not less than 51% of the total number of eligible producers have voted.
So all producers.
Yeah.
And of that, at least 51%, then the 65% of the milk, or the 65% of the producers of that 50% group.
Of that 51% in the state have voted, and find one of the following. So it's one of two. It's either 65% or more of the total number of eligible producers who voted in the referendum and have produced 51% or more of the total milk. So you have to have the 65% voted, producing 51%, or 51% or more of the total of eligible producers who did vote, who produced 65% or more of the total amount of fluid milk produced in the state. So either or. William, you were asking a question that I didn't hear. Answered it? Okay.
The other comment that I'm not sure was addressed was in regards to if there was a referendum, would it just be, black and white, thumbs up, thumbs down, or would there be some sort of hearings like in the past? Would there be some gray area to adjust, or how does that work? Or we would just strictly be voting on the petition as it came forward, and that would be it?
Yeah, I would think you would recommend you have to vote on the language in the petition as it was received. Yeah.
Notwithstanding the petition, the PRB at any time can make recommendations on other policy proposals for the QIP, correct? Mm-hmm. They're not bound by a petition process.
No, they can come forward with their own suggestions, recommendations, yeah.
Okay, so we don't have any other comments.
One more public comment?
I'm sorry, Candace,
The reason that was still highlighted is you guys hadn't finished the discussion on whether you're going to amend anything within that, based off of what Michele had said. More administrative versus.
and so
Yeah,
this
this is probably the bullet that is the most problematic, right? Because you really need the first bullet. You need to know who's submitting the petition. You have to have language, what is the petition intended to do? But yeah, it's this third bullet that I think is the problem. Because even if somebody didn't submit anything listed in the third bullet, we're still gonna take it and consider it. So it'd be nice if all of that information came in there, because it makes findings easier, but it is problematic. Not enforceable.
So to be clear, if I have five.
Excuse me.
Hello? Okay. So to be clear, if I have 5 dairies with 5 producer numbers and 5 tax IDs, I get 5 votes.
if all 5 of those are operated under XYZ Dairy Inc., then that would be 1 vote. If you had XYZ Sub A Inc. and XYZ Sub B Inc., then each of those separate incorporations or LLCs.
So the answer is I get 1 vote if I have 5 dairies and they all ship different places, and I have 5 tax IDs and 5 producer numbers, I get 1 vote.
No, I think he's saying if you have 5 tax IDs, you have 5 votes.
If those tax ID numbers are issued to 5 separate legal business entities, then you do get 5 votes.
Perfect, thank you.
But if they're under the same ownership?
If they're under the same ownership, well,
Tax
the
ID
ownership.
numbers would have to be different.
Under the ownership, that if, say it's an LLC, the LLC is the owner.
Right.
But they have separate tax IDs and separate producer numbers, right? But the same LLC.
So if you have the
So
same,
they wouldn't be the same LLC, they have separate tax IDs.
and I don't know what IRS provisions are for issuing tax IDs, but I would be surprised if they issue a separate tax ID, 2 tax IDs for the same LLC.
I would concur.
That's a little jacked up on your side, I think. Yeah,
How's that?
well, I mean, I have a bunch of dairies, and, I thought we pretty much established that if it was the same ownership, even if it's a different tax ID number, because I could have an LLC, I could have a sole proprietorship, I could have a corporation, I'm still one guy and 1 vote is what that's really kind of the way it is. Otherwise, I can just split my vote up every time too,
So-
and then when people start voting, they gotta get pretty clear, how many votes do I have,
And so
Pretty
that's,
soon we gotta educate everybody out there.
so then that's when we have to go back to the code, as was mentioned earlier. I don't recall who pointed that out, but the definition of what a producer is, what a person is. A person doesn't have to be an individual standing up, walking around, eating and breathing. A person could be an LLC or a partnership, so we would have to go back and review those code sections.
Yeah, and then you're gonna have to educate every single dairyman in the state as to how many votes he's allowed to have. And even on the petition too, because if they start signing the petition on 5 different lines, you like, hey, R.E. DeYoung, DBA, Hollandia Dairy, R.E. DeYoung, DBA, DeYoung Dairy, or whatever it is, I mean, that gets a little ambiguous. So I would hope that you guys had it, I was kind of hoping that you had that sorted out, but it sounds to me like you don't.
What if you have
Wouldn't they
multiple
each get a
personalities?
different, when you started the referendum and you sent out the ballots?
Yes, when we send out the
If you had the
ballots.
5 different entities and they were separate with separate tax IDs, they would go out that way, so I think that's.
If we have that knowledge up front that they are separate LLCs, when we've gotten notified from their cooperatives or their handlers or whatever the case may be, that this person is this is the owner of ABC LLC, and we have that on file, then we would issue a separate ballot for that person. So in the last referendum process, we sent out some ballots to Joe Dairyman. Here is all of the quota certificate numbers that we are going to be counting under this 1 ballot, 1 vote. Producer got that. CDFA, I see you have 3 quota certificates issued under this 1 ballot, therefore 1 vote. I'd like to point out that these 3 dairies are all separate partnerships. I'm in my partnership with One Son over here, myself on this one. Okay, provide us some documentation supporting that. Thank you very much. Here's a replacement ballots, now you have 3 votes. So it's quite a bit of work up front to look through all of the names and information that we have and compile those ballots and send them out. And then it's still up to the producer. We rely on them to look at that and decide or give us feedback if they think we have it wrong.
And then how many signatures can I put on a petition?
You could put 30, I'm only gonna count one. I mean, so, the petition, I see what you're getting at. Can Ari sign 5 times, one for LLCA, one for LLCB? That's a good question. I don't know the answer to that right offhand.
So
We need to
wasn't one
kinda
of the
sort that
items
out
that
here a
you
little bit.
asked on the petition, so remind me, because on the petition, they should identify, so it's a signature and they're identifying the producer that they're associated with, correct?
Yes.
So Ari could, if he identified 5 different
LLCs.
businesses, then you would have to count, right? And then when it comes in, you verify it like we would do based on our records, right? Because I don't know why the petition would be treated differently than the actual referendum vote.
I would agree with that. And since you would be telling me what to do, I'd say yeah. Unless I could find something in writing that was very clear why you were wrong this time, which I'm not very good at that.
What is required on the petition is actually the next bullet down that
good.
isn't highlighted. And that's the way it's defined. It says the producer name, producer number under the QUIP, physical dairy, ranch address, signature of the producer, and signature date.
So is that enough information, Don, that it would
Yes.
get us to where?
But again, let me go back and point out, as was pointed out earlier, the definition of producer isn't necessarily a person that's walking around eating and breathing. It can be an LLC or a corporation or a partnership.
That makes sense. So now I have another question. If I have 5 dairies, what? Oh, 5 dairies, but they don't have separate tax IDs, but they do have separate producer numbers, do I get 5 votes? That's one part of the question. So the answer is no. Okay. But does the total milk volume of that one vote for all 5 dairies count towards the 65%?
Yes.
Thanks.
I'm just wondering, Dan, I'm just wondering if all the answers we're giving these questions we're 100% confident are the right answers. Because as I'm sitting up here, it sounds like there's some doubt when Ari asks or AJ asks. Should we maybe make sure we know the right answers to these before we start giving them?
So I know the right answer that if it's a separate corporation or a separate partnership, it's going to get a separate vote. That's what we've done all along. And that's based on the definition of what a producer or a person or a person is in the Food and Ag Code.
So at some point, would it help, I mean, since we're taping this, that maybe we produced a document that said, here's questions, these are the questions that have been raised about how votes are counted. And then we provided those answers, just so that it's really clear,
Sure. Like
everybody.
an FAQ on that very issue.
Yeah, so that everybody, and then we put it on the website. This is how you're gonna be counted, so that everybody knows ahead of time. And then if you're one of those folks that are lucky enough to have 5 dairies, you make sure you get your 5 votes, right? You're gonna read that online and know what you need. You should be receiving 5 ballots. And if you didn't get your 5, then you call Dawn. So maybe we'll put an FAQ up.
And just a point of clarification, given the cost of production and milk prices, if you're unlucky enough to have 5 dairies.
Yeah. You know, you can only vote for
Amen.
directors on a board, 1 vote, 1 person, right? And the thing of it is, it's pretty inconsistent with, I mean, how many times can I vote for Trump, you know? I mean, that's a little bit different. And how many times can I vote for president of my co-op? That's just 1 time, right? So in the end, it gets a little ambiguous when you guys are the only ones doing it a little bit different than everybody else. But it's consistent with what you've done in the past, but I'm not sure that, you know, I mean, if I have 11 dairies, holy cow, man, I get a lot of ballots.
But if you were a partner, so say you have, you know, Ari.
I know, but I got
Ari and
several dairies that I
Sons.
own by myself.
Right, but what if you're Ari and Sons and Ari and daughter and Ari, right? And you're only you're a partial owner, or it's 50-50. Those other folks, though, that it's a completely separate business, they're being kind of denied their vote, I think.
But I'm a little bit like AJ. You know, I got one dairy in an LLC, I got another dairy in a sole proprietorship, and another dairy in a corporation, you know, so I have multiple votes, is the way it sounds here. Yeah,
You just have, you would have numerous individual votes,
yeah,
right? So
yeah, and
for
I
the
don't know
business.
that that's consistent with anything else, you know? And nowhere else would I be allowed to do that, except here. I can't even vote at CDI.
Or wherever you ship.
Yeah, well, that's where I ship too.
It seems a little inconsistent, though, that you would have two dairies that are partnerships owned by the same people that you wouldn't let vote, but you would have two dairies with LLCs owned by the same ownership, and you do let them vote separate. So if you just change the structure of your business, you get another vote.
So it's not that we are choosing that or being arbitrary about that. We would always point back to the definition of a producer and a person in the Food and Ag Code.
But under that scenario, even if you only got one vote and you had two dairies, the milk production part would all count towards.
That's correct. Yes. The milk production from both farms would be added together for the volume purposes.
Does somebody without quota have a certificate?
They do not have a certificate, but they do have a number assigned to them.
Oh, they do?
Yeah.
Okay. So that was the number you were referring to when you say we're looking at their pool number or whatever it is?
Yep.
Ready?
Set?
My name's Peter Baum, I dairy in Bakersfield, and I have one dairy and one vote. And I'm just sitting here watching this thing today, and I'm trying to understand, you're the attorney, right, Michelle? Correct for the state?
Allegedly, yeah.
Yeah, okay. You're administrating this thing, right? And Karen makes the ultimate decision? Is that right?
Yep.
This is a review board, not a rules-making board, or is this a rules-making board?
They are an
Advisory.
advisory to the secretary.
Okay. So she's gonna take what you revised today and make her own revision, if she wants to do that.
Yes, she can. So she could take this and change it if she wanted, tweak it, yeah.
You said in the beginning, I believe, that you all want us to decide as dairymen. I don't have any quota. Sorry, I know you do. If we get to decide and you truly want that, the industry is, Craig, what percent quota?
23% quota is issued, but there's about 45% that's quota.
We're getting off
So,
subject.
yeah.
Okay, here you go. Just relax, I get a minute. What percent of quota is owned by this board that's making these rules? If you really want us
I
to
don't know that.
be a picture, it's 75.
It's a valid question.
And I want the Madam Secretary to know that.
Valid question doesn't need an answer.
Okay.
All right, just wanted to make you all aware. It's on the record, correct?
The fact that you asked a question's on the record and what it is, from the department standpoint, my answer is, I don't know what percent of the quota is owned by board members.
Right. Well, I just stated it, so it's on the record. I mean, I'll stand on one foot, take a selfie with my signature, do it upside down if y'all want me to do that to prove I'm signing my deal. It really seems like this is make it as hard as possible to go through the process, which has already been outlined. And the only reason I can believe why is that the board is a percentage different than the industry, which is what we're really after. I think we are. I don't know. That's all. Thank you.
Thank you. Any more discussion by the board?
Still got another public comment.
No.
You're tired of hearing from me, I know. Briefly,
My comment was that in the past, this board has taken public comment for a specific period of time, and then it was over, and there was no more public comment. So I was just wondering how they're doing it today.
You sure?
Nothing with you.
Understood. No, I just thought I'd make one last comment to dovetail on Dawn's comments with respect to this discussion about votes and how votes are counted and who's entitled to vote. I would completely disagree that it's an arbitrary approach to determining who votes. It's very clear under the statutory provisions as to who's entitled to vote. Every producer, which has a definition, is entitled to a vote. Producer is defined as any person that produces market milk from 5 or more cows in conformity with the applicable health regulations of the place in which it is sold, and whose bulk market milk is received, acquired, or handled by any handler or any nonprofit association of producers. And in turn, the term person, as it's used in the term producer, is defined as any individual, firm, corporation, partnership, limited liability company, trust, incorporated or unincorporated association, nonprofit cooperative association, or nonprofit corporation, or any other business unit. So it's very broad in its definition, and it is intended to include, as Don pointed out, not only a walking, talking human, but any business entity. And that is clearly provided for under the code.
I would just like to point out, that attorney agrees with me more than you do. That's not true, by the way.
That wasn't very nice.
Okay, we're finished with public comments. Where are we on the draft petition procedures? Do we need to vote on the final thing?
Yes.
So do you want to just consider one more time what was raised about that third bullet? Those requirements that we really can't enforce, whether we want to leave them in there or whether you want to just take them out and just ask for the very specific information that's required, like who are you, how do we contact you, what does your petition say, here's what we need on the signatures.
Brett?
John?
We can either strike this all, or can we just put our suggested at the end as a means?
That works.
For the petitioner?
Because then I would clearly send a message that, yeah.
I mean, you want some kind
recommended.
of guideline format that we're all talking about apples and apples as a petition's coming in. And so if this is suggested, I don't think it's as a hurdle to get over. I think it just seems to present a sense of order as it's coming in. I'd vote for that. So I'd suggest that.
I'll second.
Move supported. Any more discussion?
Just when we get public comment, one more time. I got one quick thing, and it's back to the question I asked.
But
Does this have to do with this?
is this,
But I know that, so let me just jump in, because I know this might not be exactly what Bagley-Keene requires, or like, but this is really important, and the secretary wants to hear from everybody, and she would be upset if we cut any public comment off. So I think we're just gonna have to be patient, and if things come up and you all wanna comment, we need to get it on the record.
Okay, we'll stay here all day.
And it's actually not a new comment, so it's back to the bullet point, not this bullet point, but the one where once it's turned back to you guys have one or more meetings to, give your opinion to Secretary Ross. So, to me, you gotta have some kind of a fine, you have a minimum of this many days, and, maximum to this many days, but that one or more is open-ended. So, it always, in business, it always comes back to math and making decisions based off of calculated risk and all kinds of different things. But if you can get this referendum presented to you guys and you have the choice to review it over 6 meetings, and that means 3 years, that's a big difference for me as a producer deciding what to do when I have an opportunity to do it, so to me, there should be some type of maximum amount of days from the time this thing, is certified that it's good, that there's got to be a recommendation to Secretary Ross of what your guys' opinion is, because, right now, it's wide open, and I don't think it's most documents are not that vague. So it's just back to the same question.
thank you.
So why would you need, so my question would be, why would this board need more than one meeting to review a petition? Because petitions aren't going to change, right? So you're going to see the petition, and it's gonna have all the signatures, and we know you can't amend the language on the petition, right? And you're not required to verify the signatures, that's gonna be programmed, so why, I mean, I think they're making a good point, why would you need more than one meeting? I mean, if you think you would, then, but really, why would you need more than one to review it?
Maybe on what the economic analysis of the actual petition would do, what it would do to milk flows if that changed the flow of milk. I mean, there's a lot of pooling provisions in the federal order. I mean, this thing keeps spiraling. It's all connected. I think any change in equity in the industry is gonna have a change on where milk comes from. And I think it would be ignorant of the board not to recognize that. So I don't think what the petition comes in on a certain day, it would be ignorant if we didn't realize what that would do to the industry as a whole. And we can't have all that information in one day.
But what will you do with that information? Because I mean, so you calculate economic impacts or what does this board do with that information? I mean,
I think
to keep
ultimately that would affect our recommendation to the secretary.
So you think that if you might come up with a recommendation that said, you need to deny this petition, even though it's over 25%, you need to deny this petition from going to referendum? I mean, you think that's a possibility?
That's a possibility.
Okay.
What if we were deadlocked and we had an even number of producers? We would probably need another meeting.
You know, it took us a long time to get where we're at. I
Yeah.
don't know that there needs to be any kind of rush. And that's a huge decision, you know? And you're affecting a lot of people's lives. You know, people that own quota, people that have had it for their entire lives, people that, you know, have been in the dairy business for many years, you know, and how it affects those people is huge, you know? So we can sit here and say, yeah, you know what, we can make that decision today. Yeah, we can. You know, is it the right decision? Why does it have to be rushed? Because it is a big decision. It affects every one of the producers in the state, so.
Costing us $13 million a month that we wait. Every month we wait's $13 million, and that's a pretty big consideration we need to consider. We've talked about this quota thing for years. We don't need how many more meetings you have to have, but it's all the reg says right there clearly, 25%. There's 11 people here, 15 to recommend against it. You're gonna have 250 people on that thing saying that we believe we should go forward. So it's 250 against 15 if you wanna do it by numbers basis. And I think that it's just clear in the regs. And to answer your question, Lance, if you look under the 62717 and you look under where that came from, there's strict standards in there about how many days we can do this thing. And it's in there. I think it's 60 days, 30 days. Receipt of the, as Director Seska was talking about earlier, she has like 21 days, don't quote me on all this stuff, it's like 21 days once she gets the receipt to verify the numbers and say she's received a deal. And then it takes, the election's 60 days, they have an alternative to do it, extend it another 30 days if they want. And then when that decision comes in, the votes counted, that takes like 30 days. And then they have like less than 15 to implement it if it passes. So it's about a 6-month process. Once we submit the petition, it takes about 6 months. It's pretty well spelled out. They can have all the meetings they want here. It doesn't affect the code that says that we get to vote. It's a mandatory, triggers a mandatory referendum. So we can talk about all we want. We're just an advisory board. And you are giving your recommendation to the secretary, which is there's 15 of us here, and the 250 are saying, this is our recommendation, we want to go to vote.
But frankly, that's my question, right? So it might sound like I don't have quota. I got 30% quota, and I bought most of it recently. So, I mean, if you want to look at economics, I'll get hit harder than 95% of the total because mine's fairly current. But in business is business, right? You got to have information to make a business decision. So how does someone make a decision at this point where, you know what, I might want to bail on the quota I have because this could happen in this speed. Or, oh no, someone's telling you, no, this thing will get drug out for 3 to 5 years. Well, then that's another business decision. Well, you can't make a decision if you don't have numbers. So if it is already written in code somewhere where this is the timeline, once signatures are submitted, and it'd be nice to know where that is. I'm not trying to skew it either way. If you guys say you got 3 years to decide, I don't care. I just think it should be defined, and maybe it is defined somewhere, and I just haven't read it. But to me, it's important that whether you own quota or don't own quota, you know what the rules are. The rules can't be vague, is my point. This looks vague. And maybe there's parts somewhere else that I haven't read that is very not vague. But that's my point, so.
Good question.
One thing that we may be able, I know we've been adding sentences and words here. I mean, we could just add the line that the PRB shall work with the department to act expeditiously in order to resolve the issue. I know from a programmatic perspective, always on the agenda, we say, when's the next meeting? And everyone checks the calendar. And if it's something of critical nature, we've had meetings as quickly as 2 to 3 weeks.
Can we look at more language? So does this actually, so we have set deadlines for the department, for the program to be reviewing and putting out all the information. Does this actually put a hold on our timeframes as we move forward? I can't tell because I'm only seeing part of this.
Now, right now, we did remove the certification process. And if I'm looking at my time frame scribbled on a piece of paper, I believe the only time frame primarily we have 90 days to certify the petition. But I believe we removed the certification process, which was the department needed to initiate it within 21 days. Then there was a 30-day response
Yeah, but
period.
that's been taken out.
Right, but what I'm saying is, right now, I think it says the department shall take 90 days to certify the petition. My question is, we could probably do it in less time than 90 days, and that would abbreviate part of the process, because somebody mentioned 225 days, and they were correct, based upon the certification process was included, but we removed that, so we may be able to shorten the time frame if the board considers that. Realistically, I don't think it would take for 250 signatures. I realize there's questions we have to ask. Are they a producer? What's the definition of a person? But do you think we could do something quicker than 90 days if we got the petition?
Yes.
Okay.
Yeah.
Yeah, so that may be something that 45 days, 30 days seems a little bit of a, depends on the time of the year. You have to run the quip too every month. Would 45 or some shorter period? I don't want to put.
We could do it in 45. And we probably could do it in 30. But that 90 days that was put up there, that was also tied to 90 days elsewhere. So that 90 days that you're looking at there, that didn't extend the time frame that we're looking at to get through the process.
Right, okay, good point.
Could I comment on Lance's comment? I agree 100% with what Lance said. It's really holding up the whole industry. Nobody knows what the future of quota is. And if you just bought it recently, you can't sell it for another 2 years unless you apply for hardship, the way I understand it. So now you're trapped with no options whatsoever, and I don't think that's fair or fair to the industry. But personally, I don't know what the answer is, Lance, and I don't know if anybody else up here does either, but it really has affected the industry as a whole, and vagueness does seem to be where we are.
I think everybody, no matter whether you have quota or not, everybody needs certainty, right? I mean, it's the uncertainty that impacts the economics and the decision-making, right? So I would agree, any place that we can tighten the time frame that it takes, you know, I mean, this is Don and his team that have to do the verification. But any place that we can tighten it or bring some certainty, even to that section that talked about you guys meeting for one or more meetings, okay? Well, maybe we put a cap on, but no longer than 60 days. Or there's something that doesn't say, okay, you can have one or more meetings, and yeah, we'll have our next one in 3 months or something. I mean, we need to put hard deadlines wherever we can, because this is state government, and you know how things, they get pushed out and things go out, and that's not what we want here. We want to tighten this as much as possible and hold everybody accountable, including you guys. If you're gonna have more than one meeting, then maybe there has to be a quick turnaround. You have a meeting in your back in another couple of weeks, right? So that we can get a referendum out there and a vote, so.
You know, those deadlines are tough because sometimes things happen and you don't really have control. Maybe you could put a parameters that time between meetings so it doesn't get stretched out too much. But if you say you have to accomplish it in one meeting or in 30 or 60 days, you back yourself into a corner. And that's probably not a good idea, because if you violate that, then what's the penalty after that? Now, all of a sudden, you've got another issue to deal with because you've missed your self-imposed deadline and you have to punish yourself. I don't know where that goes.
I'd like to make a comment at the risk of getting myself in trouble, but they talk about stability. Pooling quota was authorized in 66, was implemented in 1969. Never since 69 has the 25% petition request been used. There was stability in the quota structure. That was always there from the beginning, was never used. Everyone understood what the quota structure was doing. It made this stability in the dairy industry. Now it seems to be tearing apart for some reason, or the ability to tear apart is there, and that's a problem. When we went to the standalone quota program, it was the understanding that we probably wouldn't get the federal order if we didn't have the standalone program. So now we have the federal order program, and some people believe that, okay, now we can create the instability and throw it out. To me, that's wrong. I'll fight against it. I'll talk against it. That's where the instability is. They talk about the quota prices going up and down, the value of quota. It's because of that instability that is created by a few.
If doing the right thing creates instability, then so be it.
Not a few, it's a lot.
So, do you want to consider some tightening any deadlines or adding any deadlines?
I believe we
anywhere?
still
You
have a
just-
motion on the floor.
You just want to leave it?
Yeah.
I'm sorry.
We still have a motion on the
Oh,
floor.
I'm sorry.
We better clean that up first.
Oh, okay.
And I didn't write it down. Do you remember the motion?
It was to suggest on that third bullet point.
Or
that it-
suggested.
Suggested.
Yeah.
Can I ask a quick question? I don't know the process of this. To Lance's point of putting a timeline that the review board can speak or give recommendations, does the review board have to have a quorum each time in order to submit a recommendation?
Yeah, they could meet, if they don't have a quorum, they could meet and have discussions, but to put a recommendation forward takes a quorum because they have to vote on that.
Okay, because then there lies the problem a little bit. To Peter's point, if you've got a board made up of majority quota holders, all you have to do is not show up.
Well,
And
the
you don't have a quorum.
secretary can move forward without, if we have a review board that's not meeting or we can't meet a quorum, then she has the authority to move forward.
Okay.
Yeah.
Okay.
Moving back to the motion on the floor. What?
It's up there in the highlighted section.
I'll second it.
Oh, and that was, it said changes, the
Yeah,
last words
it's-
were the change, okay. And that
Changes are suggested, yeah, for the proposed
That was
changes are
supported?
suggested.
I support it.
and supported. Any more discussion by the board? I think we've had enough audience discussion on this one, too. Ready to vote? All in favor, aye.
Aye.
Opposed?
So now are we going to entertain a motion to approve the whole document?
The
Don?
record says yes.
Okay.
We are.
I'll move that we approve this whole document in its entirety.
I'll second it.
Oh, you wanted to make sorry, Michelle.
I didn't know what you guys had wanted to do on the 90 days.
The 90 days?
That was the last.
No motion?
But Don, you said that coincided with somewhere else that you were tying those 90 days to?
There was a 90 days here, and you added the 90 in a prior section that you had tied to that 90 below. And so the 90 that she's pointing out now, my comment was that 90 days didn't extend the process because it was tied and in with the one that was down below. So it didn't extend the process at all.
I would make the motion to approve it the way it's written so far, without any amendments.
I'll second.
Any more discussion? So the 90 days stays in the way it is. And all the other things that we talked about and approved today were included. No more discussion? All in favor, aye?
Aye.
Aye.
Opposed? Move, motion passed. Okay. Form 700, you really have to go through those?
You have public comment? So, yes, we do need to go back. We did entertain public comment along through the process under agenda item number 5. We do need to go to agenda item number 6 and offer another opportunity for public comment on anything that anybody would like to talk about, even if the board is not taking an action on it today.
Okay. Public has the ability for further comment on any subject.
Just Jeff Vanden Heuvel, Milk Producers Council. Just a request that this draft, as completed, gets posted timely on the website, like, today or tomorrow, so we can see it. There's been a lot of changes. It's been hard to track. So I'm requesting that it gets put on the website immediately.
Well, this would be run by legal first.
Well, and thanks, Jeff, for your comments, and we'll discuss that.
Any other comments? Okay,
Okay, Form 700.
item 7.
Sorry, it's Jeff. I just wanted to remind everybody, if they haven't already, that Form 700s are due at the end, April 1st. If you're a new member, we have a Form 700 system or database. If you're a new member, if you have not already, you should be receiving an email from the system with your password and directions on how to log on. If you're a continuing member, and many of you are, you'll also should have, or if you haven't already, you should be receiving an email about completing your 700. And I will check back with my assistant, Kathy Dias, to confirm that the emails have gone out. But I just wanted to remind that April 1st is the deadline, so you have about 3 weeks to complete the Form 700.
Regarding the Form 700, I did try to go and had some questions. I think the password or the first thing, there's 2 things. There's a password and there's a user ID.
Yep.
Your user ID is, at least on mine, was my email.
Okay, fine.
And then when I went to the password and tried to go forward, I tried to use, they asked for my last name. They said it didn't match up with my email. Then I went to Kathy Dias's, it said if you have any questions, email her.
Right.
I did, and I never got a response.
Oh, all right. I will make a note, and I will circle back. I know let me check. When did you email her? Was it just recently, or was it probably?
I'd say a week to 10 days ago.
All right. I'll make a note.
I mean, I have no problem taking care of this on the side and not here in front of public, but at the same time, I mean, I don't know if any other board member had the same problem I did, but I did reach out and never got a response.
All right. Thank you.
Just for clarification, this is my first meeting. I'm setting further agenda items as far as like the assessment of the 38 cents. How does that play out? How does that all work out? Setting agenda items for future meetings.
So you can request that we put that on the agenda for the next meeting, and we can do that. It's just, anybody can request at any time just by email to the department, or it can go before the board and just asking that that be considered.
Thank you.
Next meeting? Have a reason to schedule one?
I don't have a reason to schedule one at this point. At some point, we will be looking at the amount of collections that are coming in and the payments out. We'll be doing that within the next couple months, and we can either communicate to the board just via email. I don't know that you would want to convene a formal meeting just to discuss that. If you do, that's fine.
To go down, no.
Yeah, at this point, I know normally the budget season is usually around August, September, and that's when we would provide fiscal information and things of that sort. And we haven't had any requests for hardships or anything, which if we did, we would notify you immediately and schedule a meeting. Yeah, so unless there's some other reason for a meeting, we can sort of say August or September and get back to you in a few months, unless there is reason to meet sooner.
Sounds good. We have to do anything on 9?
Travel expense claims, if anybody has travel expense questions. Steve, you look like you're,
I can email them the forms, but yeah, you can work with me on that.
so Steve Donaldson has got that under control. So if you want to touch base with him after we've adjourned, he can point you in the right direction, and you guys can coordinate what you need to do.
If a petition is submitted, and I know the process we've talked about, but will the board be notified that somebody has submitted a petition? Or
The whole world will be notified.
apparently so, but, and what would be the process to notify?
So we would email the board members, and we would post that petition on our website.
And then start the certification process?
Yes.
And there would be a date where you'd say, we started this date and we anticipate being done by that date?
Yep.
I think the next step in the process, though, will be putting this on the website, and we'll be running it up to the secretary, because at this point, this document is a recommendation, but I think it's a very strong recommendation. I think we fine-tuned it. It'll be up to the secretary, I'm hoping in the next several days, for her consideration, and we'll get back to you with the final results of the document. So, but I think we've done quite a bit of good work. I think we've refined it, and I'm not seeing any issues with it. And legal, thank you for general counsel for providing her direction and guidance on it as well.
Need a motion to adjourn or just adjourn? To adjourn. Moved and supported to adjourn. All in favor, aye.
Aye. I want to get one last one.
Meeting's adjourned.
Meeting's adjourned.
Take care.
See the next one?
Greg? Always a pleasure seeing you guys.
Greg?
You fly up or you? No, I drove. I'll be driving back.
Not with the truck, though, on the bike.
Yeah, no, I didn't ride. A little wet for that.
Oh, wet, yeah.
Because when it warms up and dries up, I love riding that bike. Lets my head breathe a little bit, you know?
Well, guys my age probably switched over to the trike by now.
Yeah.
Adam Will Dyke, just want to formally introduce myself.
Will Dyke?
Yeah.
DYT.
Yeah, I know.
Yeah, Chino.
Chino.
Chino Dyke.
Yep.
He's a good kid. He's on the CDI board.
Still in Chino?
Sorry, it's okay. Don, always a pleasure.
See you, buddy.
All right. All right, always a pleasure.
Hey, where's your bag? Oh. I could have sworn I saw a picture with that. Stop shoe I see.
Oh, no. I have it on my head.
He gave it to me.
Good job. So it's basically just the roles, right?
We'll be all right. See you later.
When I was talking, there was a drip.
That was on my phone.
You're gonna be late.
Yeah, Monday, Wednesday, and Friday is lunch day.
Is that right? Is that how it works? Maybe
Yeah, I know, we can't compare the two anymore. They've already covered the formula, so I don't know. I'm pretty sure we can play about trade and things like that. I put the other mic up here. It'll work out.
Why would you limit him that way? Tell him to be good.